People.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbley, who is standing to my left.
Good morning. Mr. Crumbley, can you hear us?
Yes, I can.
All right, you can be seated. I was here last night, and I have a few rulings for you. The first would be about, I believe, about Exhibit 45, 52, and 62. And those all have to do with texts from the shooter to Jennifer Crumbley during time periods when the defendant and his wife were also taking photos of themselves at a horse farm together. At least that's what the metadata and the GPS shows. So I reviewed 62, 52, and 45, and the court finds that those texts would not be admissible because they are between the shooter and his mother. There's no information whatsoever, with the exception of the fact that Dad is with his wife, as demonstrated by pictures and texts and GPS, metadata, and all those things, all those tools that are being used by the prosecutor's office to track people's movements in this case. So they are together, but there's no evidence whatsoever that Dad was on the receiving end of that text. And in fact, I know that in both 52 and 62, the statement from Jennifer Crumbley appears, "Where's your dad?" So I don't find that there's enough support to believe that Mr. Crumbley was aware of these texts. He could have been aware of these texts. We just don't know. And because of that, those texts will not be admitted.
Good for
and
you.
that also makes, I think, the information at the horse farm inadmissible. Clearly, if Mr. Crumbley were to testify, or if it became relevant, I can see the prosecutor saying, well, do you raise horses? Did you spend a lot of time with your wife horseback riding, whatever it might be? So the pictures of the defendant and his co-defendant at the horse farm might be relevant and might come in for other reasons. But the texts between the shooter and his mother will not be admitted because there's no evidence that the defendant knew about those. So that's that. I think you then asked me about Exhibit 78. Exhibit 78 is in conversation. I don't recall if it's Instagram or
It's text.
text.
It's just,
And it's between the shooter and his friend. And it's a text that says, "Hey man, times have gotten rough ever since you left. I don't know if you're dead or you moved away, but I hope you're doing well. I'm about to do something really bad, and there's no turning back, so I'll probably never be able to see you again. I hope the best for you, and I'm sorry for anything I've ever done." And that's dated November 30th, 2021 at 8:21 in the morning, the date of the shooting. And it's to the shooter's friend, who's been previously not identified by name, but identified in this case. So I read a series of cases, including the case submitted by the prosecutor in this matter, to indicate that there is an exception in this matter. But there's not, that this is not hearsay evidence. But I read a series of cases interpreting that issue. And one of those is People versus Stubble. I think it's 149 Michigan 42. In that case, hearsay testimony was given by a prosecuting witness who testified that the defendant had approached her several times to discuss prostitution. And in that matter, the challenge to the evidence concerning the witness's testimony that one of the older men propositioned her friend. So this text in Exhibit 78 is offered by the prosecution under 8033. 8033 applies if it is an exception to the hearsay rule if the declarant's state of mind is at issue in the case. That's also stated in People versus Lucas, 360 Northwest, 2nd, 162. Also a Michigan case. This one's
You
from
can hear from another
1884.
courtroom.
People versus Lucas, that also says the court's ruling that the testimony was admissible under the state of mind exception to the hearsay rule pursuant to MRE 833 was also error. Only when the declarant's state of mind is an issue in the case is evidence of his state of mind admissible. In Lucas, they asked about the state of mind of the deputy in the case. And in that case, they determined that the state of mind of the deputy who was one of the authors in the case was not an issue. Then there's People versus Fisher, 449, Michigan 441. I believe that's a case that the prosecutor relied on. That case also says talks about statements and marital discord. In that case was the issue. I believe it was a murder, husband and wife. And in that case, Fisher says, in the case at hand, marital discord, motive, and premeditation are all an issue. Thus, the statements of the victim wife are admissible to show the effect they had on the defendant husband. They were found admissible under a state of mind exception to the hearsay rule. I'm not going to admit People 78 because the defendants, although the defendant's state of mind in this case might be admissible, the shooter's state of mind is not an issue. We all know the shooter's state of mind on November 30th of 2021. Additionally, there were requests for Facebook messages. I believe those were 160. 161 was ruled on, am I correct?
Yes, Judge. I think it was 118, 153.
Was it 133?
Oh, I'm sorry, 118, 133, and 153.
150. So I'm not going to roll on 133 right now. There's something else I want to look into, but I find that 118 prosecutor notes 801C. I believe that entire chain is hearsay and does not fall under any hearsay exception, so I will not be admitting under 118. Sorry, Mr. Keys, did you say 153?
Yes, Judge, 153.
I have 133, but I'm going to pass on that. I'm going to have to look at 153 again.
It's the last text in the 118 and 153. They're the same text conversation. It's just a different portion. It's the last text. It's the text from Jennifer Crumbley that says, Ethan, don't do it.
All right. I can get back to you on that, right? You don't need to know before opening. Okay. So with regard to 133 and 153, I will continue my homework assignment.
Thank you, Judge. Just want to recap, make sure the record's clear. The court's ruled on exhibits 45, 52, 62 today,
Correct.
78 today as well.
Correct.
Yesterday, 308, 321. Those are two different photographs ruled inadmissible yesterday. We redacted photographs 258, 259, and 260. They were an issue. We gave a copy to the defense counsel this morning.
Okay.
We agreed to limit exhibit 80 yesterday. That's the DoorDash text message conversation to just the 26th to 30th of November.
Okay.
And the rest were ruled to be admissible yesterday.
Is that your understanding as well?
Yes, Your Honor.
And the court's reserve on 133 and 153.
133 and 153, and you don't know before openings for those.
I do not, Your Honor. And I'm sorry, Mr. Keith, did you indicate 118 was also not admissible?
I should have, yeah.
Okay.
133 and 153. I also wanted to ask you, there was some discussion yesterday. Members of the media have requested a copy of the questionnaire that was provided to the jurors. I don't have a feeling about it either way, but if you agree to release it, I will. If you don't, so I don't.
I really don't have an opinion on the jury and panel. I don't see an issue. Why not?
The defense also does not have an opinion on it, Your Honor.
All right, so anybody who wants to can email the chambers and we'll give that to you, all right? So, wait, Julian.
Okay, one issue. When we approach,
All right, good morning, everyone. I hope you're all having a great day, by the way. I'm on civil law. We're going to watch this at least for today and see where we're at. And we now have the best court audio of any channel, because we've put in secret post-processing. We have better audio than court TV. We have better audio than Law and Crime. We have better audio than anybody. We have the best audio. So, hey, we try to make it as good as we can for you. Tell your friends. Yeah, I know. Tell people. We have the best audio. We clean it up and make it better. We get all the audio settings nicely compressed so everything sounds great. Clean up all that static. We clean it up. Best audio. Plus, if I can be so bold, the best legal commentary. Why does dad have headlines phones on? I mean, you could think about it for just half a second. Obviously, he's hard of hearing, and it's to make it easier for him to hear. I mean, think for half a second. I'm just saying.
I guess I'm asking to remain standing because I'm going to swear you. Right? Can you all raise your right hand? Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm going to ask you to swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you're discharged by the court and from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. Thank you. You may be seated. I appreciate you being on time. I do. I have to give you some initial instructions, and then you're going to hear what it means today. All right? And don't try to write down what I say because I speak way too quickly, and because you're going to get a full copy of these instructions when you go to the jury room. All right?
Jeopardy, by the way, just attached in case anyone cares.
I'm going to explain to you some of
Jeopardy
the
attaches when the jury is sworn in, so Jeopardy has
attached.
attached. Exciting.
I'm going to tell you the elements of the charge. The defendant is charged with 4 counts of involuntary manslaughter. The prosecutor has alleged 2 separate theories of defendant's guilt, which may be established under either or both of the two theories. The first theory of involuntary manslaughter is doing a grossly negligent act causing death. To prove this charge under the first theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, in count 1, that the defendant caused the death of Madison Baldwin. In count 2, the defendant caused the death of Tate Meir. In count 3, the defendant caused the death of Hannah St. Juliana. And in count 4, the defendant caused the death of Justin Schilling. That is, that Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. There may be more than one cause of death. It's not enough that the Defendant's Act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. Second, in doing the act that caused Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, we must find each of the following 3 things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious.
This is Jeopardy as a sound clip. That sounds fun.
As previously noted, the prosecutor has alleged 2 separate theories of defendant's guilt. The second theory is gross negligence in failing to perform a legal duty. In the second theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to prevent their minor child from intentionally harming others or prevent the minor child from so conducting themselves in a way that creates an unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform
so we got the audio levels really nice too, so that when I talk, it talks and it's louder than the court, so I can talk over the court, which is nice.
Tate Muir as to count 2, Hannah St. Juliana as to count 3, and Justin Schilling as to count 4 were directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling died as a result of defendant's failure to exercise reasonable care to control his minor child, so as to prevent him from intentionally harming others.
It may be the judge's courtroom, but this is my channel. I'm the captain now.
Others, knowing that he has the ability to control his child, knowing of the necessity and opportunity to do so. There may be more than one cause of death. It is not enough that the defendant's act
it's also well balanced. Yeah.
In order to find that
so the court peaks out at about -16, and I peak out at about -10.
And Justin Schilling were caused by the defendant.
It's only a difference of 6 decibels.
Natural or necessary result of the defendant's
I've given this some thought.
With respect to the alternate theories, it's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt.
Do I have a P.O. box? I do, in fact, have a P.O. box. It is on my link tree. Type !link tree for all my contact information.
This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. I've just described some of those to you, and you'll hear them over and over again. And they'll also be in your jury instructions.
This is preliminary jury instructions. Yes. In this jurisdiction, they provide some instructions at the start of the trial. So these are some instructions.
Is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a
Yeah,
doubt based on
25% louder
reason
sounds
and
about
common
right to me,
sense.
right?
A reasonable doubt
It's like
is
I just want to
that.
be slightly
A doubt that's
louder
reasonable
than
after
the court
careful
audio,
and
right? I want my
considered
voice to
examination
be
of the facts and
I
circumstances
want my voice
of
to
this
be
case.
obviously dominating, but I don't want to be so
I wanna
dominating
mention,
that the
these
court
cameras
audio,
in the
you can't
courtroom.
hear it if you don't really
I
want
don't
to,
need to be
right?
concerned
So a
about
25% difference
the video cameras
is probably
and the
about
still
right.
cameras
I have
will
given
not
this
be
some
taking your
thought.
picture at any time, so I want to make sure you know that. A trial
Yeah.
follows this procedure. First, prosecutor makes an opening statement. The prosecutor gives their theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or she may wait until later. These statements are not evidence. They're only meant to help you understand how each side.
Did they seat the
views
jury yesterday?
case.
Technically, they seated it
Next,
about
the
5 minutes
prosecutor
ago.
Presents their evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right
Technically
to
correct is best
cross-examine the
kind of correct.
prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses,
Oh
the
yeah, we
prosecutor
now
has the right
also
to
have Cash
cross-examine
App.
them. Prosecutor may also call witnesses to
So I
contradict
gave up
the
Zelle.
testimony of the defense witnesses.
And that we just have Cash
After all
App.
the evidence has been presented,
So,
the prosecutor
yeah.
and the defendant's lawyer will
We
make
now have
their
that
closing
option.
arguments. Like the opening statements, they are not evidence. They're only meant to help you understand the evidence and the way each side sees the case.
So far,
You
my
must
home is a
base
happy
your
place. I'm a
verdict
happy
only on
camper.
the evidence.
I'm enjoying it. We got a nice little setup. I really am enjoying the setup. It's much more professional.
The trial is run fairly and efficiently.
It worked out
to make
pretty well.
decisions about evidence
I
and
think.
to instruct you about the law that applies to this case.
Looks
You
nice.
must take the law as I give it to you. Nothing I say is
I'm getting some more powerful LEDs
about the facts of the case. As jurors,
in
you are
via
the ones who will
Amazon.
decide this case.
Okay,
The
super chat.
responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence.
Thank you,
and
Tony
all
P,
the
for the 10 gift
testimony, and then
memberships. Laurie
decide
V.
what each piece of
Laura V
evidence
gives
means and how
$10
important
to
you
say
think it is.
uncivil. Please enlighten
This
me.
includes how
I'm a
much you
family
need
law
what each-
attorney, but can't
what each of
legally
the
get my head
witnesses
around these elements
What
and
you
how it's
decide
supposed to
about
work.
any
The duty
facts in this
causation
case
of it
is
makes
fine.
sense to me.
Part of your job
Well-
in deciding what the facts of this case are is to decide which
When you
witness
have
believe
criminal liability
and how important you
or
think their
liability
testimony
period
is.
in a civil
You do not have
context,
to
even
accept
for
or
that
reject
matter,
everything a witness says.
it's either
You're
because
free to
you
believe
did
all,
something
none, or part of any
or
person's
you didn't do something that you were
In deciding
required to
which
do,
testimony
right?
you
So,
believe, you should rely
in
on your
both
own
criminal
common
and
sense
civil
and
law,
everyday
and for that
experience.
matter, family law,
However,
I would
in deciding whether you
imagine,
believe a
right? You
person's
can have
testimony, you
liability
must set aside
both
any
for
bias,
doing
prejudice
things
you may have based on
and
the
not
witness's
doing
disability,
things
race,
when you're required to do
national
those things.
origin, or ethnicity,
And the requirement to do
gender,
things can come
gender
about a number of
identity, or
ways.
sexual orientation,
Most notably in this
or
situation
religion,
by being a parent.
age,
Parents have
or
an affirmative
socioeconomic
duty
status.
to their children.
There's no fixed set of rules for judging whether
And
you
so
believe
the
a
failure
witness,
to do
but it may
things
help
can
you to think
be
about these questions.
the
Was the witness
liability.
able to see or hear clearly?
So if
How long was the witness
if you
watching or
didn't
listening?
do
Was
what you
anyone
had
else
to do
involved in my
and the failure to
undistracted
do it
witness?
caused the
Does the
problem,
witness seem to have
you're
a
liable.
memory?
That's basically the bottom line.
How does the witness look and act?
I hope
while
that answers your
testifying?
question.
Does the witness
And
seem to be
Maria
making an
Z
honest
gives
effort
10
to tell
gift
the
memberships.
truth?
Thank you.
Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his
How do I
or her
feel about the
testimony?
Jennifer Crumbley verdict?
Does the witness
It was
have any bias
correct.
or prejudice
It
or
was
any personal
correct
interest
given the
in how this case
evidence
is
offered at
decided?
trial. I think
Have
the
there been any
defense fucked it up.
promises, threats, suggestions,
But that's a
or
criticism
other
on the defense,
influences
not the
that
jury.
affect how the witness testifies? In general, does the witness have any special reason
I
to
mean,
tell
it's
the truth
correct for the
or any
jury at
special
least. Let me
reason
put
to
it
lie?
that way.
All
I
in
still
all,
have
how
doubts on the
reasonable does
underlying
witness's
legal theory.
testimony seem when you think about
I
all
don't
of
think the
other
Court of
evidence in the
Appeals was
case?
right, and the Supreme Court of the
When
state
it's
may
time
yet
for you to
overrule
decide
them.
the case, you're
But
only
was
allowed
the
to consider
jury's
the evidence
decision
that was
correct,
admitted in this
given the
case.
information and law they were
Evidence
given?
includes
Yes.
only the sworn testimony of witnesses, the exhibits admitted
But I
into
still am
evidence,
not.
and
I still
anything
don't
else
believe in the
may be
underlying
considered
legal
as
theory.
evidence.
But that, of course, isn't what the jury is supposed to do. They have to apply the laws they're
The
given it.
questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is.
I think Dad's chances
I may
depend a
ask some of
lot
the witnesses
on
questions myself.
whether or not this defense lawyer
Sometimes I assume if
is
I'm
competent.
confused about something, someone else in the jury would be. These questions are not meant to reflect my opinion about the evidence. If I have a question My only reason would be to ask about things that may not have been fully explored. If you can't hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I'll rule on these objections according to the law.
The defense attorney is from the same firm.
Are not meant to reflect my opinion.
Yes.
About the
There was a whole
case.
conflicts of interest
The lawyers and I will
discussion in an
definitely have
earlier
discussions on
stage.
the
Yes, they
hearing.
are of the same
Also,
firm.
while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I'll send you to the
You're
jury
welcome,
room for that
Angela. Would
purpose.
you try to get the
Then
audio
you
as
should
good as we
discuss the
can?
case amongst yourselves, but only in the jury room and only when all the jurors are here. You must not
Thank you,
talk to
Jen, for the
defendant,
5 gift
the
memberships. We
lawyers,
do really
witnesses,
appreciate
or
it.
anyone who may
Just a
be
friendly
connected to
reminder,
this
by the
case.
way,
This
we
means
do
that
appreciate the
you may
people
not speak
who
to these
subscribe to us
individuals,
on
even
Twitch.
if
It
has
gives me
nothing to do
money.
with this case.
And if you have
You should
Amazon
be very
Prime, it costs
cautious
you
about
nothing.
Speaking to people. because
So
you
just a
may
friendly, and you do have to renew it every
inadvertently
month.
speak
So a
to someone
friendly
connected to
reminder.
this case.
You can also
This
watch me on
restriction is
Twitch. We're
necessary to
simulcasting
avoid
on
the
Twitch.
appearance of any
So you can go over there
improper
and you can hit
conduct
the
on any
subscribe
person's
button and
part. If anyone tries to
give me
discuss
some
the
of
case with you
Jeff
or in your
Bezos's money.
presence, tell them to
And set yourself a
stop.
reminder to
Explain
renew
that
it.
you're a juror and
Thank
that you're
you.
not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. I mentioned before that it's helpful.
And thank you to the 12,900,000 views that we've gotten on this channel.
Okay.
Leandra gives 10 gift memberships. Thank you very,
During the
very much.
trial,
We do
you not
appreciate
read,
it.
Listen to or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow these instructions. The
He'll be
restrictions
found
I'm about
guilty.
to describe
Depends
are meant to
completely
ensure
on
that
whether or
the
not
parties
he.
get a fair
I think
trial.
there's possibilities for him. I think
In our
there's
judicial
possibilities for the
system,
wife.
It's crucial that jurors are not.
But it's really going to
influenced
come
by
down to the
anything or
defense
anyone
case. I think the
else
defense
in
has
Under the law, the
defense has
evidence you
ideas.
must, consider has to meet certain standards.
Maybe.
For example,
Laura
witnesses
V gives
who swear
$5
tell
say
the
to
truth,
clarify. I struggle
and
to see
lawyers
how the
must be
general
able to
duty
cross-examine them.
for a parent extends to this
Because
kind of
information obtained
foreseeability.
outside
Intentional
court
school
does not
shooting.
have these
Well, on
safeguards, it could
foreseeability,
give
I tend to
incorrect
agree with
or
you,
misleading
which is why I'm
information
critical
that
of
might
it as a
unfairly
matter of
favor
law.
one side.
I don't really think it's foreseeable. The Court of Appeals thought it was foreseeable. In fact, they went one step further. The Court of Appeals thought a reasonable jury could conclude that the parents could have foreseen that a shooting was going to occur on that day.
This means that until
And they said
your
on
verdict,
that day
you must not
twice
read, watch,
in their
listen to,
decision.
or receive any information,
And to my
including
legal
opinions
mind,
or
and
commentary
it appears
about the
yours
case,
as well,
whether in newspapers,
I'm
on
like, that is a
television,
lot of
radio,
foreseeability,
internet,
man.
or
That
on
is just a
social media
lot of
platforms.
foreseeability. That a
You also
person
must
could
not research
predict
any aspect of
that
the case during
a
the
shooting
trial.
was going to occur
This
on
means
that day.
research
That's a
using cell
lot of
phone,
foresight.
computer,
So
or
yes,
other
I have
electronic device to
questions
search the internet,
on how
as
you can
well as
conclude
research
that
with traditional sources
as a matter
like
of law,
dictionaries,
let
reference
alone matter of
manuals,
fact.
newspapers,
But
or
that's where we're
magazines.
at. So,
You must not
okay.
investigate
It
the
must
case
be
on
true,
your own
Laura,
without
because the
any
Court of Appeals
experiments
said so.
concerning the case,
Okay.
including investigation or experiments using the internet, cellular phones, computers,
But
or
I
other
have my
electronic
doubts,
devices.
too.
You must
So,
not visit
yeah.
the scene of any event in this trial. If it's necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider
Thank you, B.O.
evidence any
Blazy, for
personal
becoming a
knowledge you
member
have on
for
the scene.
99 cents. We do appreciate all of our
You must
members.
not share any information about the
And
case by
thank
any
you,
means,
Snarky Old Lady, for the
including
5 gift
cellular
memberships.
phones or
They
social
are
media.
appreciated.
This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other manner. If you discover that a fellow
Yeah, it's
jury
nuts. I
violated
tend to
my
agree.
instructions, please report
I don't
to
really
the
agree with the
staff.
Court of Appeals, but
You
that
may
Court of
take notes during
Appeals
the trial
said
if you
it
wish, but of
is
course you don't have
foreseeable.
to.
And I'm like,
If
okay,
you do
well,
take notes, you should be careful that it does
apparently
not
that's the law,
distract
I
you from paying
guess.
attention to all the evidence. when you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If
And
you take
incidentally,
notes,
and
do
not for
let anyone
nothing, and I don't
the
know
other
whether or
jurors
not the
see them
defense
during
preserved the
deliberations.
objection.
You must give them to my clerk when you leave
So
each evening.
there
Your
might be
notes
a
will not
problem
examined
there
by
because
anyone.
I
And
think
when your
that
jury service
when the Court of
concludes,
Appeals
your notes will
said
be collected and
that
destroyed.
a jury could
It is
conclude
possible to replay
that a
a
person
witness's
could
testimony
predict a
on
shooting
your
was going to
request if
occur
the conviction
on
was
that
due
day.
yesterday.
That sounds
However, you would be
suspiciously to
required
me
hear the
like
entire
what the
witness's
jury is supposed to
testimony.
be
You
able to
can't
find,
fast
right?
forward to a certain
That's
part
the
and
thing
follow
they're
along.
supposed to be able to find,
Okay? It's
that
not
they could have
fair to both sides. You
predicted
would have to
the
hear
shooting
that
was going to
entire
occur
case.
on that day. That sounds like what the
There's
jury is
more than
supposed to
one
find.
defendant involved
Was
in
that
this
in the
matter.
jury
You should
instructions?
consider
No, it was
only the
not.
evidence presented
The jury
in this
instructions did not
defendant's trial.
say
Each
anything
defendant
resembling,
had his
hey,
or
you
her
members of the
case
jury
decided on the
must
evidence
find
and the law
the
that applies
facts
to him.
that they could have seen this coming on
can
that
see that there are
day.
15
Nothing
of
even
you,
resembling
who
that
have
was
you
even
in two
close
different jury rooms
to in the
just
jury
for,
instructions.
comfort. After you've heard all the
So
evidence
there's
in the
actually a
instructions,
pretty
you will
reasonable
draw lots
argument
to
on
decide which
appeal.
of you will
The
be
jury was
dismissed
given the
to form a
wrong
jury
legal
trial.
instructions based on the Court of Appeals' own
Possible
instructions
penalty should
if
not
the
influence
defense
your
preserved the
decision.
issue.
If you find the defendant guilty, it is
Which I
my
don't know if
duty
they
to fix
did.
the penalty within
But
the
that's
limits
also where we're
provided by
at.
law.
So all kinds of
I'll
fun
definitely
and
be giving
exciting.
you more instructions throughout the trial.
You say the
After
jury.
all the
You say
evidence
the
has
jury
been
could
presented,
conclude
you'll
that
hear the lawyers'
they could
closing arguments.
the jury could
Following
conclude
closing
that they
arguments,
could
I'll review
conclude a
additional
shooting would occur on that
instructions
day,
about the rules
and then
of
you
law
don't
to
ask the
apply in
jury
this
whether or
case.
not they concluded
You
that a
should
shooting
consider
occurred
all
on
my
that day.
instructions as a connected series. Taken
Yeah.
all together, they are the law you must follow. After my final instructions, you'll go to
Yeah.
the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to maintain an open mind and not make a decision about anything in the case until you go
So
to the
I
jury
have
room
my
to decide the
doubts.
case.
Also,
You must
by the
not
way,
let
not for
bias,
nothing, if you go
prejudice,
read that
or
Court of
public
Appeals decision,
opinion influence
it's a
your
little bit
decision.
circular.
Each of us may have biases for perceptions.
It's a
about
little.
other
It's a.
people
It's in.
based on
It's in my
stereotypes.
humble
We may be
opinion,
aware of some of our biases,
circular and
though we do
hand
not
wavy.
express them. We may
They
not
kind
be
of
fully aware
they
some
kind
of
of
our other
gloss over
biases.
parts in the
Take
middle of the
time to
reasoning.
read,
Kind of
test
hope you
what
won't
might be
notice.
automatic or
Gets a little
instinctive
fuzzy there at
judgments, and to
parts.
reflect
Little
carefully
magic
about
trick.
the evidence. I caution
I'm
you
like,
again
yeah,
to
wasn't
avoid reaching
the most
conclusions that may have
persuasive
been
argument
unintentionally
I ever
influenced by
read in my
stereotypes.
life.
You must reach your own conclusions about this case individually.
But then, unfortunately, I'm
But
not
you
on the
should do
Court of
so
Appeals,
only
so
after
what can I do
listening
about
to
it? Not
and
much.
Considering the opinions of the
If
other
you elect
jurors
Kurt
who may
Mueller
have
for
different
Michigan
backgrounds
Supreme
and
Court, maybe.
perspectives from yours.
I'm not a resident of Michigan, but you know, whatever.
All right, so we're going to hear openings. Oscar.
On November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized the entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. Anna was 14 years old. Madison Baldwin, she was 17. Tamir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home. What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable, and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. During this trial, you're going to hear about events from the spring of 2021 through December of 2021. November of 21 is the critical time period, especially November the 30th. But that earlier evidence is going to give you some context into the family life in the Crumbley household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap. What happened was foreseeable, especially to his father. I'm going to talk to you about some of the evidence that you're going to see through this trial. We'll start with this. This is a 6-hour 9mm handgun. This was a firearm purchased by James Crumbley as a gift for his son on November the 26th, 2021. This is a picture taken by the shooter, found on his phone, the day that gun was brought home. This is a Instagram post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun. Took my new SIG out to the range today. Definitely need to get used to new sights, LOL. This is a post from Jennifer Crumbley, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and son day testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. You're going to learn that it wasn't just those 2 extra magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase. You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer, and went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time. You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021. You'll learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range, even buying himself a .22 caliber Kel-Tec semi-automatic pistol, and his son a different gun, .22 caliber 2-shot Derringer. That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see some of that. Some of this background is going to shed light on what happened in November of 2020. This is a pivotal month in the Crumbley home. As I said, the shooter had one and only one friend. That was no secret. James knew about that. You're going to see evidence that the shooter and his friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he didn't. It was also during this month of November that the defendant's son began to write in the journal. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he was able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that 6-hour 9mm handgun for his son on November the 26th, and then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest, the most glaring opportunity to prevent the shooting, a full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is the math worksheet. These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley. You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James and Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbley, she's in blue. Call now, all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband, James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbley's response, "My God, WTF." And then he says what he was actually doing that morning. "Vet not here. It's McElmurray's Procurus horse. Still waiting on the vet." You see, James and Jennifer Crumbley spent quite a bit of time away from the home, attending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbley, he said he was distraught about last night. "James, we talked about it this morning." "You talked to him?" "Jennifer, can you call? That heading to his school, I'm very concerned." That was at 10:04 in the morning. Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6-hour 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting note. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. It was one of the most glaringly missed opportunities. But instead of seizing that incredible opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries. Never once bothering to stop by his house, which is just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so. Never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. Their reunification point was the Meyer and Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one person who called the police that day to identify their kid as the suspected shooter. It was James Crumbley. This nightmare, these murders, were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I didn't even tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. And you're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence would be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December 4th, 2021. That's after they were charged with these crimes. Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbley gave his son that firearm hoping he would murder more students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. It's two reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder or aiding and abetting murder is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation in an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case. It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the three elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually two different ways to find this defendant guilty of involuntary manslaughter. You're able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. That gross negligence caused death, and not the cause. It was a cause of death. And that's important because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is the failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we are here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act, right there, is his willful disregard of danger, right there. You're going to hear a lot of evidence and arguments in this. It's important that we all understand that you're not here to talk about, to decide on parenting. This case isn't about parenting. It's not illegal to be a bad parent. It's not kids doing kids things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was showing a clear statement of intent of what the son was going to do. That is when that rare set of circumstances is present in these specific set of facts. James Crumbley is in charge with what his son did on November 30th. James Crumbley is charged with what he did and what he didn't do on November 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured, when shown this picture. That's what this case is about. when this kid was begging for a more deadly weapon. That's why we did it. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged. Thank you.
Good job.
Thank you.
8.5 out of 10.
Ms. Lehman, would you like to make an opening statement at this time?
Yes, Your Honor. Thank you.
Good job. Solid job. 8.5 out of 10. A little paint by numbers, but well executed. Could have used a little bit more
The
vocal
events of
variety.
November 30th of 2021
well done.
undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access is not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training, to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Not bad. Not bad. A little bit vague.
I'm going to give you a little break. So
I would have preferred something a little bit more concrete, a little bit vague. Vague isn't necessarily bad for an open, because you're just trying to set the overall story arc. I would personally prefer it a little bit more detail. So I'll give her an 8 out of 10. It's fine.
And Councilman High Coach briefly. With the jury's up.
Much better than her compatriot in the Jennifer Crumbley trial. I was very glad not to hear about Taylor Swift again. I have to tell you that. It was a little. Yeah, the only real criticism I have of it is it doesn't really refer to any specific evidence, and it just kind of boils down to, in my view, an admonition to make the state prove its case, which is not necessarily the strongest footing. If there are, for example, in the Jennifer Crumbley case, we know this from the motion practice, the state wanted to bring on an expert, the state's expert, who would have testified about pathways to violence, right? And so there's various pathways to violence, and people could know this.
We're breaking down, right, Judge?
Yeah, I'm just trying to get rid of some paper.
And the defense objected to this witness being called, but for my money, I said not only do I want this witness called, I would call this witness myself as the defense. Because one of the other things this witness would have testified to is basically how even the experts can't really predict these things. They're not predictable. There's been studies, I can't speak to the veracity, but apparently there's been studies among professionals who are trained, FBI officials, cops, that kind of thing, who have trained them or have asked them by giving them, for example, messages or something, is this person a mass shooter? Right? Because the mass shooting's already occurred in this, by the way. The mass shooting has occurred. They just don't know who it is. They just know, all they're given is like the messages. And it's like, is this person a mass shooter? And apparently the experts only get it right something like 30% of the time. And so I'm like, well, that sounds like really good evidence for me as the defense. So I'll call this witness myself, basically. If they want to talk about pathways to violence, that's, I'll live with it. But if I can get this witness to tell me how even the experts can't predict this, that sounds really, really good to me. So I thought that was a misstep based on my understanding. That sounds like a misstep. Let's not file a motion to exclude. Let's file a subpoena. Let's make him our witness. That sounds really good. And so if there was testimony like that for this trial, if she intended to call such a person who would have said that, presumably she would have mentioned it in her opening, and she didn't. Her opening was kind of vague. It wasn't bad, but it sounds like she doesn't really have anything specific. And again, you just need an allusion to it. You don't need to sketch it all out. You don't need to go into laborious detail. You need to still let the witness be the star. You just have to establish the framework. But there really wasn't... The framework was kind of vague. And makes me wonder if she has anything to work from.
Yeah, turn it around. Oh, my camera, I moved it.
She didn't really testify about... She talked about...
Actually, I don't know. I guess I can't give you the answer.
I'm going to go ahead and mute this for the second and pull myself full string because there's nothing much happening. Right? It's like, yeah, if you're going to bring on evidence, you need to make better allusions to that in your opening to tease it like a movie preview, like any preview, right? You want the teaser. And we didn't really get the teaser. We just really got, they're going to talk about how the gun is stored. We'll talk about that. They're going to talk about this. We'll talk about that. We want you to apply the law. We want you to apply the law. So in some ways, it almost echoes the prosecution, and it's a little amorphous for my taste, and it makes me a little afraid for the defense because, the defense can win this. I think that at least they have options, but they really need to attack the foreseeability element. I think is the way to go, and they didn't really suggest they were going to do that. So I don't know, man. I have my doubts. We'll see. Maybe they're holding it in reserve, but I have questions. No, they're not done for today. They're just taking a break. They're just taking a break between opening arguments and calling the first witness. For whatever reason. I don't know. They're on a break. So good morning, everyone, and welcome to Uncivil Law. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court. And as always, I hope you're having the bestest of days. We turn our attention once again to the Crumbley trials. This case, James Crumbley, Ethan Crumbley, the son, committed a mass shooting at Oxford High School using a Sig Sauer that was purchased for him by his father, and killed 4 students and wounded others. Ethan Crumbley, for his part, pled guilty. He was sentenced to life without the possibility of parole. He is currently appealing his sentence, which, okay, fair enough. He would like the possibility of parole very much, if you don't mind. And he's like, so he's still appealing that, but that process is ongoing. The parents are charged with involuntary manslaughter. They're being charged with reckless endangerment, essentially. They talk about negligence, but they don't really mean negligence. They really mean recklessness, because if you actually go look at the definitions, it means recklessness. And recklessness is wanton disregard. Recklessness is conscious disregard of a known threat, of a known risk. That's what recklessness is. So if we want to go through the mens rea elements real fast, right? So in the model penal code, and this is also just the way people think about it generally, even if you're not applying the model penal code, because it's just such a good way of framing it. We typically think about intent, or we think about mens rea, mental state, in 4 different versions of it, right? In escalating senses of guilt. So at the bottom of the pyramid, we have standard negligence. This is an automobile accident. All right, you have a duty to not get in accidents. Now, you're not consciously disregarding a known risk, hopefully, in your automobile accident. It's not like you were aware of a specific danger and ignoring it. You were just distracted. You have a duty not to get in accidents. You got in an accident, so barring some sort of mechanical failure, barring some sort of externality that can excuse your conduct or make you not liable, right? In your typical garden variety automobile accident, you're thinking negligence, right? You have a duty not to get in wrecks. You got in a wreck. Therefore, that's standard negligence, all right? Now, if you want to move one step above standard negligence, you talk about recklessness, and that's what they're really talking about in this case, even though they use the term negligence. Recklessness is conscious disregard of a known risk. Now, you don't necessarily need to know exactly what the risk is, because if you're willfully blind, that works too. You just need to be aware that there is a risk and that you're disregarding it. So a DUI is a classic example, right? If you get drunk or intoxicated off any substance for that matter, that is recklessness. You are disregarding a risk. Now, you're not exactly sure what the risk is here exactly, but you're consciously making the decision to impair yourself and then get behind the wheel of a vehicle. Bad omens emerge, right? Bad omens emerge. It is foreseeable based on your own conduct that this was going to end poorly. So that is recklessness, your standard DUI, for example. All right, we want to move one step above that onto the mens rea. Knowing, all right, knowing disregard. Now, knowing regard of a specific outcome, right? In recklessness, we are not necessarily aware of the specific thing. When we talk about knowingness, now we are aware of the specific thing, right? We know that a specific thing will occur, but we don't care. We are consciously choosing to disregard a known, precise event. We know what it is, and it's going to occur, and we don't care. And then finally, we get to the top of the pyramid where we talk about intent or purpose, where it is our intent to do the thing. It is we desire to do the thing. We don't necessarily desire the outcome of the thing, but we intend to do the thing. Your standard variety murder case. I shove a knife into you. I intended to shove the knife into you. Now, I may or may not intend you to die, again, because when we talk about murder, for example, we talk about different degrees of murder. So depending on what degree of murder we're talking about, I may or may not have to prove I intended for you to die. You know, typically for capital murder or first degree murder, you have to prove that, but again, your mileage will vary, right? In your typical garden variety murder, right, it's enough to prove that I shoved knife into you and you died. I may or may not have intended the death, but I intended the stabbing, and that's enough. So that's your hierarchy. So recklessness is the conscious disregard, wanton disregard, devil may care attitude. It is driving at excess speed. Truly excess speed, right? Again, what exactly are we talking about? It's going to depend, but let's say you're traveling 80 miles an hour in a 40 mile an hour zone. Kind of sounds reckless to me, right? I mean, seems like a problem. You probably shouldn't be doing that, right? So that, conscious disregard. So that's what we're doing here. And so what is the conscious disregard? Well, the idea, at least in principle, from the state, is that the parents had sufficient awareness of their child's depression, desire to harm himself, desire to harm others, that he is volatile, and they entrusted him with a firearm. And therefore, that's reckless. This is a person who is a known danger or foreseeable danger, and you gave him the tool to affect the danger. And so that is the idea of recklessness. So what we have, and then of course, we also have the idea of the not doing things. That as parents, they have affirmative duties, because typically a person does not have an affirmative duty. I have no affirmative duty to you. If you are drowning, I have no duty to save you, even if I could, even if there's absolutely no risk to me whatsoever, right? Putting aside the idea of whether there's danger to me, even if I know for an absolute certainty, and it is true, for an absolute certainty, there's zero danger to me. I could just push a button, as it were, and it would save you. I don't even have to be near the lake you're drowning in. I just have a magic button, and if I push the magic button, you will be saved. I do not have to push the magic button, because I have no duty to you. Now, that might make me a moral bastard, but, it's not legally responsible. But a parent does have duties to their children. They have duties to clothe them and feed them and care for them and so forth and so on. And one of the duties they have is a general duty to help protect the world against their own child. Now, that, of course, has its limitations, but there is a duty, like, if you could imagine a child, for example, that had true behavior issues, right? This is a truly mentally disturbed child or a mentally unwell child. And they just, anytime they're brought in public, they're always flailing around and just throwing everything. And they're just always, punching people and everything, right? And this is the child's known behavior, right? Then you as a parent have a duty to others, given this specific knowledge, to do whatever it takes to, not have your child do those things. And if they do those things anyway, then I can prove all this, then you have violated your duty to me, because you are the guardian of your child in a very literal sense. You are the parent, you are the guardian, they are your ward. And so you have an obligation to protect me from them to some extent. And so the failure to do things might be enough in this specific event. So either them buying the gun, which is the doing the thing, which was entrusting it to them, giving it to him, which seems to be what the state argued in the parent case, or parent case is the wrong term, the Jennifer's case. Yeah, whatever. I'm confusing. I was using the term parent in a different sense than biological parent, and it confused me. In the other case, that, he had access to the firearm, it wasn't secured by a trigger lock, it wasn't whatever, and so it was entrusted in a sense to him. They gave him the keys to the car, knowing, for example, that he's a drunken maniac who just drinks all the time and whatever. That might be enough. That's sort of the idea. The problem where it breaks down here for me logically is the foreseeability element. This is the idea of proximate cause, which we talk about as well. There is the idea of actual cause. A causes B, causes C, causes D, causes E, causes F, right? But for A, F does not occur. That's actual cause. But also in law, both in civil law and criminal law, although there does seem to be some variance on this issue, by the way. So on whether or not proximate cause is a thing in criminal law, there does seem to be some case law that suggests not. But, are they talking now? Are they just sticking around? Yeah, they're just sticking around. All right, anyways. So there does seem to be some variant on whether or not proximate cause is a thing in criminal law. But for the sake of this argument, I'm going to say it is a thing in criminal law. All right, so proximate cause is the idea that at some point we stop caring, right? It's just too much, right? It's just too much to hold you responsible at some point. Because you pushed over that first domino, at some point it's like, dude, man, come on, right? There's somewhere down the chain it's like, this is just not fair. And so there's a proximate cause problem here. In my humble opinion, this is the biggest problem. There's a proximate cause problem, which also goes to foreseeability, right? Because if it's not proximately caused, then how can you foresee it? That's basically why proximate cause exists. Right, so maybe we call it something else. Maybe we just call it foreseeability instead. But it's the same basic idea. Proximate cause just is foreseeability in some ways. It's basically the same fundamental thing. We stop caring because it's foreseeable. So yeah, maybe we just go about it a different way and call it foreseeability instead of proximate cause, whatever. It's the same concept, right? At some point it's like, dude, man, come on. We're not the Oracle of Delphi over here. So that's where I break down the most, among other problems, is just the proximate cause or foreseeability element. How could anyone foresee this? Particularly if the Court of Appeals is to be taken at their word, and the foreseeability is supposed to be the foreseeability to see that a shooting was going to occur on that day. The Court of Appeals said it twice. On that day. That's the foreseeability. A shooting was going to occur on that day. And I'm like, dude, man, I don't know, man. That's just a lot of foreseeability. I mean, that what parent would think that their child is going to be a mass murderer, just generally? And is it possible really to be able to foresee that much? I mean, short of them telling you specifically that, which at that point you have knowledge, so fine. But short of that, can anyone really foresee that far? I don't know, man. But in the Jennifer Crumbley trial, the jury wasn't even asked that question, which seemed odd to me because, again, the Court of Appeals wrote it twice. And I certainly would be arguing that that's a thing that they have to prove, because the Court of Appeals said that's the thing. It seems to be what they said we're supposed to prove. So I'd be, as the defense counsel, screaming to bloody heavens, you better put that in the damn jury instructions. You better put that in the damn jury instructions that they have to see that it would have happened that day. But the defense counsel didn't object. We didn't see them object. So they arguably waived the issue. Maybe. But there's some caveats there that maybe we can keep the issue despite the defense counsel being an idiot. But, you know, they certainly weren't leaping up and down about the thing. And so, and also they didn't bring any testimony about foreseeability. And what expert could we use to testify about foreseeability? I don't know. How about the very expert the state wanted to call? That was my whole point. And the state, and if we don't like that expert for some reason, I'm sure we can find one of our own, because the idea that this is not foreseeable is like not the most crazy idea anyone has thought of. I'm sure we could find an expert who could say, you know, this is just not that foreseeable. This seems like cuckoo for Cocoa Puffs land. But for some reason, we didn't do that in the Jennifer Crumbley trial. I don't know. It seems like a very odd decision to me. I question this deeply for strategic reasons. I don't know about that one. So I'm hoping that James Crumbley is going to have some testimony along these lines, because that's what I want to have here. Because it's like, dude, man, I mean, I understand to some degree that you think this child is troubled. I get it. But is that general? First of all, it's not specific. It's not especially clear that he's especially troubled in any sense that would really inflame the knowledge of a parent. Because not for nothing, a lot of people go through a lot of difficulties as teenagers. And some of them, so the idea that he's going through what could be categorized perhaps as a nihilistic phase or something, you know, or some sort of goth adjacent, you know, phase or whatever, is not necessarily the biggest revelation. And is it inherently unreasonable to give someone a firearm, you know, in that state is debatable. And even if it is, like, the foreseeability of it is like whatever, because it's like, dude, teenagers, I've had, you know, some of them get depressed. Some of them say things. Very, very few of them act out on it. How many mass shootings in school are there? I mean, really, when you really start thinking about it, I mean, not that many, really, in sort of a grand scheme. You're talking about a 1 out of a million event. It's probably rarer than that. I haven't done the math, but, you know, yeah, it's probably like 1 out of a million. If not worse than that. How many children are there in America, and how many of them will turn into mass shooters? You know, I mean, we could go do the math, but it's, you know, it's a low percentage. So it's like, how foreseeable can it really be? That's what I'd be arguing, but and hopefully I'd be able to find experts to illuminate that point. And that seems to be the strongest point. But for some reason, we didn't hear about that at Jennifer's trial, and hopefully we'll hear about James's, and that's where we're sitting. The private journal's evidence also, I disagree with. I don't understand this. This I disagree with. I disagreed with it in Jennifer's trial, and I disagree with it here. Although, strictly speaking, that hasn't happened yet, so maybe this defense lawyer will at some later point raise objections. But yeah, I don't really understand that. If they had specific knowledge of the diary, that would be really helpful to the state. That would be that, because that goes a lot to their knowledge, right? Which then goes a lot to their foreseeability, right? The ability to foresee it is going to depend a lot on their knowledge. Duh, right? How much can you foresee is going to be dependent on how much you know. So if they had specific knowledge of the diary, that would be really helpful, but they didn't. At least there's no evidence of that. You know, there's evidence that perhaps they were aware the diary existed, but there's no evidence they looked at it, and there was apparently no argument from the defense that, you know, you shouldn't necessarily, that you don't have a duty to go look at your child's diary. Do you have a duty to go look at your child's diary? Is that an obligation of a parent? I mean, it's certainly something a parent could do. I'm not faulting a parent for doing it necessarily, although we could have that discussion as well, whether it's even morally right or not. So we could have that discussion. But, you know, at least for the sake of argument, let's say it's okay if they look at it, but are they required to? That seems like a thing. And unless they're required to look at it, right? If they are required to look at it and they don't look at it, then you got willful blindness. So now you got knowledge, right? If you know there's a reason to look and you don't look, you're making a decision not to look. So now you have knowledge, right? You have knowledge of the thing. So we don't let willful blindness work. But unless you have a duty to go look at it, which I don't think they do, then you can't bring the diary in because there's no evidence they did look at it, so they don't have knowledge of it. And so there's all that. So I don't really agree with bringing the diary in. It seems like a legal mistake. And again, the degree to which you can bring that up in appeal is going to depend significantly on whether or not the defense sufficiently preserved the objection, which I think they did for the sake of the diary. But, you know, I won't promise it. Yeah, I mean, the issue wasn't really even argued, to my mind. Right? So one of two things has to be true, it seems to me, if we're going to use the diary. One of two things has to be true. Either they did look at it for whatever reason, or they didn't look at it with specific obligation that they had to look at it. And I didn't really hear argument as to either of those ideas at Jennifer's trial, so I'm still left confused on how we're using the diary. Doesn't make sense to me. Yeah. Buying a gun for a teen knowing it's designed to cause harm is beyond comprehension. Well, you have to be a little bit more careful than that. Because I had a .22 rifle when I was like 10. And it is especially not uncommon in parts of the country where hunting is more common to have a gun that is, in some sense, the child's, the degree to which they have access to it. But I had a .22 rifle under my bed. So I'm just saying it's not necessarily absurd, depending on where you live in the country. Although it might be absurd in this specific situation, of course, because what is generally true is not necessarily specifically true, and what is specifically true is not necessarily what's generally true. So there may be reasons in this specific case to draw those conclusions. It may have been unreasonable to give this particular child access to a firearm, but even if you conclude that, which I think there's potentially reason to conclude that, I still have an issue with the foreseeability element. I still have an issue with the proximate cause. I still have an issue, especially if we're supposed to prove that we could foresee a shooting was going to occur that day. So I was like, I don't know that this is foreseeable. And the Court of Appeals decision, to my taste, was circular, hand-waving, and not particularly convincing. So, you know, it's like, yeah. But we did have fun doing a deep dive on that issue. It was great. We wound up in an 1899. Yeah, this is just fun when we do like legal deep dives over here on the channel. It's fun. As we were trying to figure out the judge's rationale for allowing the foreseeability, we wound up ultimately in an 1899 Supreme Court case from the state of California about a brother who shot another brother in the gut. And that's always hilarious, right? When you do the research and you're like, why is this foreseeable? Why is this foreseeable? Well, because in 1899, the Supreme Court of California ruled blah blah blah, and I'm like, okay, well, that's one way to go, I guess.
Your Honor, calling people versus James Crumbley, case number 22279-989 FH.
Thank you. Good morning. Marquise on behalf of people.
Karen McDonald on behalf of the people. Good morning, Your Honor. Maria Lehman on behalf of James Crumbley, who is standing to my left.
I'm ready for the jury.
We are, Your Honor.
Thank you very much for all the gifts and all the super chats. We do really appreciate it. This channel is fan funded and fan supported, so we really do appreciate all of your donations. Every little bit helps, and I thank you. It pays for things such as the new background and this lovely microphone and my ability to eat, which is also pretty good, I have to say. How long is this trial scheduled for? I'm not sure. I'd say probably 2 weeks if I had to guess. What's my favorite food? Probably either Mexican or Italian, and French. Yeah, Mexican and Italian probably are my most favorite go-tos. I like sushi. I don't like spice though. I'm not a big fan of Vietnamese food. I'm not really a fan of Indian food, although a not so hot curry is sometimes okay. Yeah. Am I still doing the burner phone? Yes, it still exists, and we could bring it up during the breaks. So we may try that again today.
You may be seated. Next, can you use the first witness?
Molly Darnell, Your Honor. May I get her in the hall?
And I got new LED lights. I got new LED lights that are more powerful, so that when the sun is shining, the blue will still pop through.
Want you to step up and have a seat?
Someone said I should get a blackout curtain, and I'm like, no, that's okay. I don't want to block out the sun. So I just need more powerful LEDs to overpower the sun. Wahaha.
Molly Darnell, LLYDARNELL.
Haley Crump gives 10 Canadian dollars to say, I think it's more than 1 million. However, U.S. population is over 300 million, but there were 38 school shootings in 2023. And teenage school kids are just a fraction of the population.
So, keep your
Well, fair enough.
And if you want me to slow down, or you
fair enough. I mean,
just let me know. Okay. Can you tell the jury what
I mean, there's I mean, if I had to do a quick guess, I mean, we could look at the demographics
I'm employed
and
at
see what we're
Oxford
talking
Community
about.
Schools. I've been there since the fall of '98. So that would be your whole teaching career? That's correct. Okay. What is your role now? My role now is I am a virtual teacher with Oxford Virtual Academy. I'm a mentor teacher for middle schoolers. All right. So do you go to the high school now? I do not. All right. Can you tell the jury what your role was and which building you worked at on November 30th of 2021? On November of 2021, I was the International Baccalaureate Coordinator for the Middle Years Program, which was a 610 program, as well as the English Language Arts coach, which was a 612 position. Okay, so you didn't have, did you have instructional contact with students, or was it more teachers? No, I worked with teachers, predominantly the English Language Arts department, but I worked with many other teachers throughout the 612 curriculum. It was it's a coaching job. So instructional curriculum, that type of what's happening in the classroom. At that point in time. When was the last time you had a traditional teaching schedule? A traditional teaching schedule might have been 2015. I'd have to really go back and look at my resume to know that.
Okay.
But in the fall of 2020, I did have a classroom. We went back face to face, and so we pulled all of our instructional coaches out to teach a few hours of the day so that we could spread students throughout the building and get students back instructionally.
Okay, so after COVID, the coaching faculty
We moved back and
started to take more teaching assignments so that you can spread kids out.
Correct.
Do I have it right?
Correct.
Okay. On November of 2021, were there kids in the school that you knew? And if so, how did you have contact with them?
There were kids that I knew from the class that I had had the previous year. There might have been, having been in the district for a long time, there were a lot of teachers who had children that were in that building. So I know a lot of them too.
Okay. I'm glad you brought that up. Does Oxford have a lot of faculty who send their children to the district?
Yeah, I would say many of our faculty send their students through Oxford schools, yes.
Okay. And the kids that you knew in that building that day, did you also know them from middle school, or you just knew them?
Yeah, just knew them from knowing their parents, or if I had them in class the year before. But there might have been a kid in passing that I met here or there. But for the most part on that year, I had no contact with students other than, if like a kid wanted to stop in and see me, or if we met in the hallway or.
Okay. But did you have a traditional classroom?
I did not. I shared an office. It was like a half classroom.
Was the classroom turned into two offices or not?
Correct. It was a classroom turned into two offices. It was in one of the instructional halls, the math science instructional hall. And I shared it with two other coaches in the district.
Okay. You're the first witness. So the jury's not seeing a map of the school. So I'm going to put that up in a minute. It's already been admitted. There's no objection to that. But before I do, can you just generally describe how the school is laid out? It's a fairly new building, correct?
It is fairly new. The main part of the building was opened, I think, in the fall of '98, the year that I started with Oxford Schools. And then I think it was the fall of '04 that we started, that it became the high school. So it's a fairly new building. There is like one main hallway that kind of runs up the center and it hugs into the courtyard. It almost reminds me like if you opened it in a map, you would see it almost mirrors itself in many ways, especially the area that I was in.
Okay, and your hallway were the hallways organized by subject matter?
Yes, we had like our foreign language hallway, our English language arts hallway, we had our math section, social studies, and then science wrapped around the side. Our electives were on the outskirts of the high school.
And how did the students and the faculty refer to bathrooms and exits? How did they describe them from one to the other?
It might have been like the exit by the staff parking lot. That's how I knew them. Okay. I know that there are numbers on all the doors. Numbers are not my thing.
It's your English. Where's this? Is there a senior
there is
library area at Oxford?
Yeah, so right up that main corridor, which is like, I said, if you folded it, there's like this one main hallway. Right in the center of the building is considered the senior window, and that is right in front of our courtyard, one of our courtyards.
And the hallways, so subject matter, did you typically find upperclassmen, lowerclassmen, or it was all mixed in all throughout the building?
Well, many of the seniors did hang out in that area. There were kids throughout the building. There was no area specific for like freshmen. So.
All right. I'm going to show you now, and the jury, what's been admitted and marked as People's Exhibit 9.
Can I have this?
Yes, this should usually take 6 minutes.
Yeah, that goes on the last. It'll take a second.
Can you tell the jury what we're looking at?
This is a map of the high school. And so you see where that, it says media center in the middle and then court right below it. When we were talking about that senior window.
Right there?
Correct. So that senior window is just south of court. Like that's the senior window, that window that is on the south end of court. No, go back. Yeah, right on like the south end of court. Sorry, south.
Okay.
Maybe I'm directionally challenged.
I think
I'm sorry. I'm going to want to go north.
Okay, so what,
This would be east.
what was the number for your class?
My number is 222.
Okay, and we'll, right there?
Correct.
Okay. And then what's in the middle area right there to,
Actually, sorry, I'm not 222. I'm 224.
okay.
I was right next door to 222.
Do you see 224?
You can't see the number, but you can see between 226 and 222.
222.
Yeah, there's a bunch of names written in that. That was all the coaches, myself. Yeah.
And to the left of that, what is that area?
The other room on the other side.
That, yeah, that, what is this area? What's in there?
That area on the lower end is the science labs. On the upper end, there is I can see a bathroom to the right, a student bathroom. And
the senior area is up?
it's up.
In the middle?
Yeah, it's right there.
Okay.
Yep.
All right. So I want to draw your attention to around 12:50 on November 30th, 2021. Do you remember that day?
I do.
Okay. Did you have any kind of teaching assignment on that day?
I did not have a teaching assignment on that day. It was a Tuesday after Thanksgiving.
Okay. Can you tell the jury about the Oxford lunchtime schedule? Because it's a little confusing.
We run a 7-period rotating schedule, which means that kids meet for 6 class periods a day. The lunches have a split hour, so they have an A, B, and a C lunch. If they're A lunch, they go to their class the second half. If they're a B lunch, they go to class, have lunch, go back to class. And if there's a C lunch, they go to class, then they go to lunch.
Okay, and about how many minutes is passing time, generally?
I want to say it was 8 minutes.
And what did you typically do during passing time?
During passing time, I might have gone out in the hall and chatted with a colleague or two, checked in on something. That is also a time it's like the time that teachers need to get things done. So there might be a quick interaction. I might, see a kid in the hallway passing by. But pretty often, like it was just standing guard outside my room or standing outside my room.
Okay. At around 12:50 that day, do you remember what you were doing?
A student that I had in the fall of 2020 wanted to chat, and so she came in and we chatted for a few minutes, and then she left.
Do your as a general rule, do you keep your door open or closed?
Open.
All right. And your classroom, as we see in the map, was smaller. What was the layout of the classroom? Were there traditional student desks in there, or can you explain to the jury what the classroom is?
If you walked in straight ahead, you would have seen my desk. To the left of that, you would have seen one of my colleagues' desks, and then just on the wall closest to the hallway, there was another coach's desk.
What is at the back of the classroom when you go in the front? The wall you're facing, what is that?
There's a large window that leads out to the courtyard.
Okay. Once the student left, what did you do?
There was a few minutes left during passing, and so I walked around to my desk and opened up my laptop.
All right, and we're going
And
to
check some emails.
Okay. And are you facing the door or?
I'm facing the door, correct.
All right. And what happened next?
I'm sitting on my laptop, reading through an email. The door's open, and I notice a group of kids running by. It was a movement that I had never really seen before. They were moving, like there was a hyperness to the voices. And it was almost like they were pushing forward, like trying to move as fast as possible.
And that seemed unusual to you?
That was very unusual to me, yes.
Okay, why was it unusual?
I have never seen a group of students move like that before.
Because of their speed or the way that they're...
I think it was all of it. There was a speed to it, the tone of voice. There wasn't any like, my first instinct was that it was a fight, but a fight, because it was the only thing that, was the closest to what students would be moving quickly or swiftly to, especially in that large group of kids.
Did you stay seated or did you get up?
I got up, I exited the classroom or the office and moved about
In the hallway?
into the hallway. I moved into the hallway to see what's going on.
Okay, if you look at the map, which direction did you turn? Did you turn towards door 4?
Towards door 4.
Okay.
So I turned towards door 4.
What did you see in the hallway?
I see, so the hallway kind of bends. So I come out of my office and I'm closer to that 221, but not fully there, right? I'm closer to 221, and I'm looking and I can see all these kids rushing out of door 4, which didn't make sense to me because, again, I'd never seen this happen.
That's what you saw. Did you hear anything at that point?
It was silent. There was no noise.
Was that unusual?
Absolutely unusual.
Okay.
Yes, absolutely.
And what did you do next?
I moved back into my classroom, trying to understand what's happening. And I walk back into the classroom and I'm thinking, okay, could there be a prank? I doubt there would be, and so it's probably 10 seconds, if 10 seconds. And I hear 3 things really close together.
Okay. What did those 3 things sound like?
One was an announcement, the bells chiming in, an announcement of our principal coming over the PA and saying, we're moving into lockdown. This is not a drill.
Okay, and you, as a faculty member for this many years, what is lockdown? What have you been trained to know about that? What does that mean?
So we're trained in the Alice protocol, which means we have to use our senses to figure out what's happening. But with all of those students and with what I was hearing, the 2 additional things that I was hearing was like a loud pop, 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 and then multiple doors slamming. I moved to shut my door and lock myself in.
I want to stop for a minute. Mm-hmm. What is your experience with firearms up until this point?
Up until this point, my experience with firearms is limited. I have, however, shot a weapon, and I have in my life shot a weapon.
Okay. Have you been to a range before? Is this a hobby that you have?
It is not a hobby. I have been to a range.
Okay. When you heard the pop, 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 what did you think?
I thought in my head I could have mistaken them for lockers slamming easily.
They did not sound like gunshots to me, but I'm not really, I've been to a range once. I've not, I don't really know what a gun sounds like.
Okay, so what, you said the three things, the announcement,
The announcement, the pop, pop, pop of the weapon that I now know, and doors slamming.
okay. And what did you do?
I moved to shut my classroom door because when I had come back in, I had not shut it. So I shut that classroom door, and we have a night lock next to all the doors.
Can you tell the jury what a night lock is?
A night lock is a device that slides into the door.
Where do you slide it?
You slide it in the bottom of the door, and it keeps the door. So on my office and all of the rooms in the building have glass partitions on the side. So if someone were to shoot out that and try to get in, it would keep that door from being opened.
Okay, I'm going to show you what's been admitted as Exhibit 10. Molly, what is that?
That's the office that I had.
Okay, so that's your door open.
Yep.
All right. And where is your, this is not a picture, is this a picture that adequately reflects the normal,
No,
okay.
this was.
We're going to get to why that's like that, but where is the desk that you were sitting at?
Straight ahead, there's that tall lamp. My desk was. Anyway.
Yeah.
Yeah.
Okay. So, you said you approached the door, you shut it,
I did. I shut it.
and then where was the night lock?
It is in this photograph. You can see that bag that's mounted to the wall. That's a blood bag that we keep in all the classrooms. And then, or like a medical bag or whatever. And then just in front of that, you can't even see it. It's so close to the door.
Okay.
Was the night lock.
Okay, and I think I might have interrupted you. What is significant about the night lock, and why is it used in a lockdown?
It's a measure, it's an additional measure of barricading yourself into a room if need be.
Can you open the door if the night lock is installed?
You cannot,
What about if you had a key to the door?
wouldn't matter. You cannot open. It's like, it keeps that door from being opened. You would have to remove that metal frame in order to get that door off.
Okay, and how do you, so the person from the inside has to disengage the night lock, is that?
Yes.
That's right?
Yes.
Okay, so, you close the door and you get the night lock, and then what happens? Did you see anything in the hallway as you approached your door?
No, I didn't. I shut the door. I can hear that door shutting. It's completely silent. And I grab the night lock. And I look down at it because depending on which way your door opens, depends on how it goes into the door. And I see in my peripheral vision some movement. And so I look up, and in that moment, I see someone wearing dark, baggy clothes.
And are you seeing him through that window right there?
Yes.
Okay. Can you describe the person?
The individual is wearing a hoodie, baggy clothes, a mask, and there was a skull cap on, or like a.
So were any parts of this individual's face visible?
I did not see any. Only his eyes, and he was wearing glasses.
Okay. Had you ever seen this person before?
No.
All right. And when you looked through the door, where was this person? How was he facing? Was he facing you? Was he to the side?
At the moment that I locked eyes with him, we were standing square to one another.
Okay. Tell the jury about locking eyes with him and what you saw.
So I lock eyes with this person, and I see some movement coming from the side of him, and I realize that he's raising a gun to me. I remember thinking in my head, there's no orange tip on that gun.
What does that mean?
I had heard somewhere in my past that BB guns have an orange tip. And my body reacted, and I jumped.
You're
To the
motioning,
side.
you're
Yes.
motioning that you jump to the,
I jumped to the right, so I'm jumping this way in the room.
and at this point, the door's closed.
The door is closed, yes.
Is there a window on the other side of this door, or just what we
No,
see?
just what you see.
All right, you jump to the right, and then
I jump, I'm turning and I'm jumping to the right, and then I feel my shoulder move back. It feels like I've been stung by hot water.
okay, you're pointing to something.
Yeah, on my arm.
On your left arm.
Yes.
Okay. At this point, did you manage to get the night lock in already?
No, the night lock's in my hand.
So he could have just opened the door.
The door was locked.
Okay.
Like the lock was on it, right? I look behind me and I see, you can see the bullet hole in the glass leading out to the courtyard. And in my head, I remember thinking a BB gun can't do that. Oh, the instinct in my body was that I had to barricade this door. But I'm afraid to go back to the door to put the night lock in.
Okay, I'm sorry, Maya, I have to stop you for a second. When you, after you locked eyes and you see a gun, do you hear anything?
Nothing.
Okay.
Oh, well, there were, sorry,
okay.
there were, it's totally silent in the hallway, but I do hear 3 loud pops. They were, you could feel the force like coming, like the way the door hit, it was very forceful, but the sound did not match the force.
What do you mean by that?
It was like higher pitched than the power of what was happening through that door.
When you jumped to the side, you said then you looked inside the bullet hole, and then what did you do next?
There was a filing cabinet over on the side of the door against the wall, and so it's like a longer one, and so I grab it and I'm trying to move it, and I'm realizing I can't move it, but I know I have to get back and barricade that door.
Okay. You were shot that day.
I was.
Okay. And can you tell the jury and show the jury where you were shot?
Yeah. I'm gonna remove this. Okay.
You can step down if you want to. It's okay.
So you can see it's kind of like on the back side of the arm. It's not straightforward. Like you can't see the scar when I'm standing straightforward. So he caught me when I'm jumping on this side.
And there's
An entrance and an exit wound, and the line in the middle is where the bullet cataracts my flesh.
when you were trying to move the filing cabinet, at this point, did you?
Thanks for reminding me the mic was muted. I was just saying that, yeah,
Did you know you were shot?
sure was shot. That's all I was saying.
Okay. Were you feeling anything physically?
No, there was nothing physical. I was so focused on, I have to barricade this door.
No,
When I
Andrew,
realized
it
I
really
couldn't move that
doesn't.
filing cabinet,
I don't know
still
how
had the
much I have to
knife in
keep
my
explaining
hand.
this, but
And so I got
they
down
have
on
to
my
prove it
hands
with
and
respect
knees,
to each and every
and I
defendant.
crawled
Ethan's conviction doesn't
the
prove
length of the
it.
door, and I
It proves it with respect to
dropped
Ethan.
the night lock in.
This is a different
And it
case.
made that like ting sound.
The murder has to be established
hit
with
the
respect to
ground.
this case.
And then
I can keep
had-
explaining it, but that's just the law. What do you
Tell
want?
me about why do you say that it made a sound? Was that significant to you?
The only thing that I have to go on right now is what's happening in my space and what are my senses telling me. It just sticks.
Was there anything?
Completely
did you
different case,
see,
completely
smell,
different
or
jury.
hear anything
Right? You have to prove the homicide all over
outside
again.
of your door?
There was a smell of a cat, like a cat that might have smelled like.
You
But
could have a
I'm not
stipulation,
going
but
back to
only
a
if both
cylinder,
parties agree. Both
right?
parties
I'm
have
just
to
dropping
agree.
that in. And then I
to make a
grab
stipulation.
The rolling cart, which is also against that back
And if I
wall,
were the
and
state, I would
push it,
not
and that's what you
stipulate.
see in front of the door.
I want to
So
prove
that
it
piece
for
of furniture
every
is the
possible
rolling.
reason.
Yes.
Okay, and you could move that?
Yeah,
So,
it was really easy. It was
No
just a
stipulation because no
push.
agreement.
Okay. At this point, did you know you were shot?
No.
Okay, what happens next?
You can't hear the witness. Yes, when I speak, it does speak
come
above the
back
witness. Obviously, that's
to
the
those
idea.
windows. So I know that I need to hide in that room.
When you say those windows, the front ones or the back
The
ones?
back ones.
Stop answering
in the
questions.
back.
It's my channel. I'll do what
so
I
I'm
want.
trying to, I barricaded the door. I'm trying to make myself invisible in that space. So I go back to that large filing cabinet.
This is
and
a
move it
commentary
just
channel.
enough so that I can crawl behind it.
And we can't see that here because it's to the left. So would you be able to see, would somebody looking in the window next to the door be able to see you?
No, the cabinet was quite large and it was wide. They would not have been able to see me behind that cabinet.
Okay. At this point, did you realize you had been shot?
I knew I could start to feel blood rolling down my arm. And I
What kind
don't
It's a
think I was
graze.
admitting I was shot. Right?
It's still attempted murder.
It's not some. It was so.
It's a graze
far
reflecting
out of
attempted
what I
murder.
knew
That's
would be
something, man.
What happened? And so I just knew that if I was bleeding,
Incidentally,
I
even if
had
she wasn't
to,
hit, it would still be attempted murder. But
put a tourniquet on. But I can't get back to that bag that has medical supplies in it. So I removed my cardigan that I was wearing that day. And I used one of the sleeves to tie around my arm, put part of it in my mouth and the other part in my hand, and I just tightened it around my upper arm.
Were you feeling any pain at this point?
No.
Okay. The person that you saw raise the gun and shoot at you, did you, looking back then now, what was your impression of his use of the firearm, if anything?
Your Honor, I'm going to object to that question. She's already testified she's not very familiar with firearms. I think that she would be speculating about his use of this.
I do want to acknowledge she's testified twice before, so I do know. I'm trying to listen to, well, even though it's her third time, it's very hard for her. And so I'm trying to get her to answer my questions. So
We'll describe.
What you noticed about him?
His feet were about hip distance apart. His shoulders were square. And he raised that gun right off.
So he's not a fan of
It
the
was
lever stance, huh?
Probably a second from the moment that I locked eyes with him.
okay, just for the record, you're raising your arm at shoulder level. Was it two arms or one?
I don't know. I just remember seeing the one arm and my body instinctually moved.
Okay. So after you tied the tourniquet, what did you do? Were you hearing any announcements? Did you have a phone with you? Did you have a way of communicating with anyone?
I had my cell phone.
I would never stipulate. It's the prosecution. I'd never stipulate. Are you kidding me? I definitely want to bring this witness on the stand and hear the jury, have the jury hear it. Are you out of your
The thing
mind?
that I know to do is to barricade and listen. So I'm trying to figure out what to do next. I know that if we're in lockdown, 911's been called. There's a phone on that desk. But if I reach for him, he's there. He'll see me.
You want to turn down my voice a little bit? Well, there's a problem because, like, how much do I
And then
turn it
worry
down?
about, what's happening in the front office. So I don't want to call up there.
I mean, it's a difference of 6 decibels. How much do you want me to change it by?
And I text my husband, I love you, active shooter.
Yeah. My volume should be
Well, then
about
if
25%
you-
higher than the
Did
courts,
you let
give or
anyone know that
take.
you had been shot?
No, not at that
It
point.
shouldn't be ridiculously higher. It shouldn't be blowing it out.
Within a few minutes, I received a text message from my daughter who went to school in a neighboring district. Through social media, she had heard that there was an active shooter at Oxford High School. She said, "Mom, are you okay?" And I said, "I'm sheltered in place. I'm safe. And I love you."
I do worry about my volume. I mean, I want it to be good. I mean, I want obviously both to be heard,
And I'm just
but I do want
listening
my voice to punch a little bit above.
To
So
what's happening outside, trying to distinguish what's my next move.
What are you hearing?
always aiming to
Absolute silence.
dial it in.
I'm hearing nothing.
Were there any announcements?
There was another announcement that came on at one point, and it was to remain in lockdown. There's a hallway text thread that we have that there's no one texting on that. But
You
there-
mean the teachers
Yeah,
in that hallway
in the
have a group text?
Yes.
Okay.
no one's texting on that. But in the other part of the building, my language arts team says, I'm hearing there's an active shooter. And I said, I saw one.
Did you say, and I've been shot?
I did not say that I was shot.
Okay, is there a reason you're not telling anybody that you've been shot? Is that because you didn't want to really understand it, or?
Thank you, Lisa, for becoming a non civilian. We do appreciate everyone who joins the channel by hitting that beautiful, beautiful join button. Thank you, Lisa.
I also think that what I know is that building has to be secured to save the most amount of lives. And telling anyone that I'm shot when I'm not, when I do not need help, is not beneficial.
So you didn't want anyone to help you?
I did not need emergency medical attention at that moment. Or at least that's what I felt.
Okay. How long do you think you were in that classroom behind that cabinet?
I've been there for about, I would say 20 minutes. And I'm sitting on my bum. And at one point I hear footsteps in the hallway because my back's facing that hallway. And I think they're starting to evacuate those rooms. That was the decision. That was the moment I decided to text the teacher next door to me.
Or
She's
on
in
one
room
audio channel with
222.
commentary in the other. It's an interesting idea.
And
I could do
just
that.
said,
Although when I'm not speaking, it would
no
lead to the
one-
problem where you'd only have
no one
audio
knows
coming
right
out of
now,
one channel.
but
I'm not sure that's better,
I
but
think I used the word hit.
An
hit in the
idea.
arm. And then I did say, I hope there's no one else. She then alerted. I believe she called 911, and there was another teacher in the room with her, and he alerted the front office.
So at some point, did somebody come to try to help you?
It was pretty quickly after I sent a text message to them that Kurt News, who was our assistant principal at the time, that he shows up at my door knocking, Molly, are you in there? And from behind that filing cabinet, I said, yes. Kurt was, I've known Kurt since I started in Oxford, but I didn't trust that was Kurt in that moment.
So you didn't want to open the door?
I did not want to open the door. It felt safer to stay in there. And then a few seconds after, there's police officers at the door, and they're like, are you injured? And I said, yes. And so they asked me to, I think I said, do you want me to, I kind of like crawled out from behind, and I was like, do you want me to take the night lock out? And they said, yes. Do you want me to open the door? And they said, yes. And I'm still on my hands and knees at this point. They reach up with a handle. And that door swings open. And they grab me from under my arms. And they pull me up and out of the classroom. And I can see Kurt standing on the lockers, like against the lockers.
Okay. I'm going to show you what's been admitted as Exhibit 11. What is that, Ronnie?
That's them at my door. And that's them walking me out. You can see that there were multiple police that were around that door when they pulled me out. And then the two escort me out door 4. We get outside of door 4 and the one says, I'm going to put a real tourniquet on you now. It might hurt a bit. And then
Is that what's happening right through the window? You can see in the
Yes.
video? Okay.
And then they said, we're going to call and see if there's an ambulance available for you. We need to know if someone needs it more than you.
Okay. When you came out, we see somebody there, an officer with a weapon.
Mm-hmm.
Were there anybody else? Was there anybody else in the hallway? Were there any students?
There was no one in the hallway. It was completely silent, with the exception of a walkie or two that was going off.
And what information did you have at that point about the shooter, or did you know if somebody, if they're still in the building? Did you know if there were victims? What did you know?
I have no idea about anything, but when he says we're going to see if there's someone else, I think it was the moment that I knew there was someone else.
When you got outside, what did you see or hear?
There's a helicopter flying above the building. There's a couple of snowbanks.
Did you see any students?
There were a smattering of people throughout the parking lot. I honestly couldn't tell you if they were students or parents.
Okay. Eventually, did you get into an ambulance?
I did.
And where were you taken?
I was taken to Lapeer hospital, or the hospital Lapeer.
Okay. And what happened when you got there?
We get to Lapeer, and I asked to walk in. I felt like if I could walk, I wanted to walk. And so they supported me to walk me into the hospital. And as I'm walking in the hallways, the doctors and nurses, like they were prepared for a disaster.
Okay. What did you learn about your injury that day?
It was through and through. It was clean. They ended up doing a chest x-ray on me in the hospital to make sure that no debris from the bullet came in. And that was probably the first moment that I cried, because I felt like I had made a mistake in the classroom. And then I had actually put my life in danger. I didn't know if I was hit somewhere else.
What do you mean you thought you made a mistake?
I didn't know if I was hit somewhere else. I couldn't understand why they were doing a chest x-ray on me.
Okay. Were you released that day?
I was. My husband came out to the hospital to come get me. We went home that night.
At some point, were you informed or shown where those shots landed?
Yeah. He was aiming to kill me. Those shots were intended.
Okay. I want to back up. When did you learn where those shots landed, other than you knew it hit your arm?
My husband was my nurse at home, taking care, cleaning my wound. And at some point when, I'm holding him out, I realized that's a heart level. And he was aiming.
Okay. How many inches is it from your heart, Molly?
I would say about 6.
Okay. At some point, when you shown the picture of your door that depicted, okay,
Yeah.
do you remember when that was?
Yeah, I saw that photo in your office.
Okay. When you came in months ago to talk about testimony. All right, Molly, I'm showing you what's been in Exhibit 12. Is that the classroom, your classroom door?
It is.
Okay. And the pink rods, do you know what those indicate?
The bullets that came through the door.
Okay, and when you saw that in my office, what did you say?
He was aiming to kill me. So that's a shot to the head and 2 to the chest.
Nothing further.
Apparently looks that way.
I was going to ask you to tell me what Alice is.
Oh, thank you. Alice is a protocol that we follow. If I could remember the entire acronym, I would tell you, but it's like we have to listen and make alert. We have to make a decision. Are we going to lock down in place? Are we going to flee the scene? Or are we going to have to go on the attack? Like someone would come in the room. So it's just kind of dependent upon the situation and what decision we choose to make in a situation like that.
Thank you. Processing it.
Nothing wrong. You should be excused, Your Honor.
Yes, you can sit down on your excuse.
The next witness involved the exhibits that we spoke about earlier today.
Okay. So we have a little setup.
Yeah, the state could stipulate. They could, but why would they? Why would they stipulate?
Needs to be set up for your review. So we're going to take that now. Okay.
All right, for the jury.
All right. We are on another little break here. So yeah, so far just heard from the one witness who was shot. I don't remember it being so emotional last time, but maybe it's just my memory of the thing. But it seemed more emotional, more visceral today, which could be due to any number of reasons. By the way, I mean, I would imagine. I don't know. I mean, people who have been through traumatic events or might be more numb to it more one day, more emotional about it another day. I mean, it's just the varied variety of life. So I don't really read anything more than that into it. But yeah, I mean, and as we pointed out, by the way, of course, we point this out, the state does have to prove each and every element of the crime with respect to this defendant. So the indictment of Ethan Crumbley is irrelevant. The conviction of Ethan Crumbley is irrelevant. The conviction of Jennifer Crumbley is irrelevant. Right? The state has to prove each and every element. And of course, this is involuntary manslaughter, which necessarily means you have to prove a homicide occurred because, well, voluntary manslaughter is a kind of homicide. So you have to prove the homicide. Now, you could stipulate to it, of course. This defense probably would. But why would the prosecution stipulate? Why would they do that? Of course they want to bring the person in and actually show them and have the jury experience the horror of it. I mean, why wouldn't they? I mean, duh. So yeah, that's what's happening on. And one of the other questions you guys asked me is like, well, how many witnesses is too many? Which is a very reasonable question, incidentally, because then you're getting basically into Rule 403, unduly repetitious, unduly in its combined cumulative form is unduly prejudicial, substantially more prejudicial than probative. So you do get into a question of like, and just repetitious in general. So there is a line somewhere, but the state didn't cross that line in Jennifer's trial, and they're not going to cross it here. I mean, every witness is providing a different perspective. So in some senses, it's not even necessarily duplicative, although you can run into unduly prejudicial problems in combined form. But that isn't going to be the problem, in terms of upholding the conviction. Yeah, I don't remember showing the last time. I don't remember this testimony the last time, so I suppose even my memory faded from it. So it says something about something. So far, kind of what we would expect. Probably not going to be a lot of questions from the defense on the witnesses relating to the homicide, because what would you question them about and why? You know, so probably just get in, get out, you know, and move on to other things. Get through it as fast as you can. Maybe she was emotional last time. I just don't remember. I don't remember. It struck me as particularly impactful. So maybe I was more receptive to her emotionality today. That could be too. Maybe I just didn't notice last time. Maybe now I'm noticing. That could be true too. It all speaks to different perceptions of things and how we do, and how we all perceive things. So, you know, that's part of the human experience too. Of course, I'm not blaming you for your perceptions. Your perceptions are reasonable. And of course, you are reasonable people. So you're able to judge the facts, you know, in a reasonable way. So your perceptions are also valid. Maybe we're more in tune because the first case was groundbreaking. That could be true too. There could be any number of reasons, right? It could be it just struck you more today than the last time. I don't know. It could literally be you. It could literally be me, right? I mean, the testimony could be exactly the same, and it wouldn't necessarily impact our perceptions the same. You know, I'm assuming that, for example, you've listened to the exact same song more than once at some point in your life, just to bring an example. And I'm willing to imagine that even though you've heard literally the exact same song before, the exact same recording, you know, every time you hear it, your experience of it maybe is a little bit different than before. Or at least if it's comparable, you know, there's some variety in the experiences. So it impacts you in different ways. You know, so even where the input is the same, our perceptions aren't necessarily the same every single time. That's okay too. Why is there no cross? What would you cross on and why? As a defense, remember your goal is to zealously advocate for your client and to facilitate them being declared not guilty. So from a strategic standpoint, what would you cross on and why? And how does it further that objective? And I can't think of any particular reason to cross this witness. There's no particular, I can't imagine what juice I'm going to get out of it for the squeeze. And I certainly don't want to give the state another chance on redirect to undo whatever I did either. So it just doesn't seem like there's enough benefit to it. So why do it at all? Yeah, I mean, what is your strategic reason for doing it? How does it further your client's objectives? Not crossing is always an option, and sometimes is the wisest option, and it was the good option here. Yeah. What if he's found not guilty? What does it say about Jennifer? Helpful in her appeal? It would not be helpful in her appeal. No. If he's found not guilty, it's because presumably the evidentiary picture is different in his trial, and the jury finds the evidentiary picture provides a reasonable doubt. And then you could be critical of the lawyer in Jennifer's trial for not presenting the same evidentiary picture. But, you know, ineffective assistance of counsel is really, really difficult. It's a very, very difficult argument to make. And so, especially in a way that provides a categorical error, right? Because a lot of errors can be waved off by it not having an ultimate impact on the verdict, right? So you have to find a structural error, essentially, by your lawyer, and that's pretty hard to find a structural error. Finding errors are easy. Finding errors that matter are much harder. Did he object to the shooter's notes coming in without his testimony? Well, strictly speaking, the shooter's notes have not been offered as evidence yet. So I can't speak to what they did in pre-trial, but since the shooter's notes have not come into evidence, I don't know what objections he will or will not make in the future. We will see as the case develops. I presume in pre-trial he made the same objections, and hopefully they will be renewed here. Ethan's journal is definitely an error in Jennifer's? Yes, probably. It's hard to see the judge's rationale for it. It's hard to see how that makes sense. So I don't know if the judge issued a order on the issue. Presumably somewhere in the case file. If you guys want to do some homework, somewhere in the case file presumably is a judge's decision on what I presume is a response to a motion in limine to reduce or exclude the journal, and presumably somewhere in the case record is the judge's decision with respect to that motion in limine, and perhaps we can discuss that if one of you guys can find it. That might be fun, and we can see the judge's rationale, because I'm always interested. Maybe the judge has a really good reason that I haven't considered. That happens a lot. It was interesting, for example, yesterday, I believe it was, when we were doing oral arguments for the bump stock case, because I came out of that case a lot more persuaded by the government's arguments than when I went in. I was like, actually the government has some pretty good arguments here. This is what happens, by listening and stuff. So I'd be more than happy to read the judge's decision. Maybe it convinces me. And I'll be like, oh, okay, that makes sense. If it's a good argument, I'm happy to adopt it. If not, then not. It's fine. Present sense impression doesn't really work. Even if it is present sense impression, it doesn't really matter. First of all, I'm not really sure it is present sense impression. I don't think that's what present sense impression means. But even if it is present sense impression, I don't know that that matters with respect to the parents, because it is Ethan's present sense at best, right? So first of all, I'm not sure it's even that, but even if it is that, even if it is Ethan's present sense, without knowledge of the parents of that, then it can't influence their knowledge base. So the hearsay issue is not really the biggest issue. The biggest issue is how did the parents have awareness of it? It's only an issue if they had awareness of it. And then you could argue that the hearsay doesn't matter because it goes to the effect on the mind of the listener, which would be the correct argument, right? So if they had awareness of it and you object hearsay, I'd be like, it doesn't matter if it's true or not. What matters is that it goes to the effect on the mind of the listener. So I'm not offering it for its truth value. I'm offering it for the effect it had on the listener, or lack thereof, which is absolutely true. That's exactly what I'm doing if I'm the state. So that's the correct response. But present sense impression doesn't really get you to the idea of how they knew about it. Without their awareness of it, it doesn't make sense. So I don't get it. I don't understand that. What's present sense impression? Present sense impression is a hearsay exception that applies to when you're observing something. So what it's present sense, it's happening at the present, it's your sense. You're seeing it, you're listening to it, and it's your impression. What did you think about the thing? Present sense impression tells you everything you know. Classic example, that car's going 75 miles an hour, right? You can think of it as an excited utterance if you like. It's not quite exactly true, but the same idea, right? It's the thing that's happening as you're saying it. You're literally observing it as it occurs. And so the idea is that you don't have time to formulate a lie, right? The idea, at least in principle, is that your present sense impression is sufficiently reliable because since you're describing the thing as it's literally happening, you don't have time to formulate a lie, and therefore it is more indicative of what's reality. So you would say, okay, so I say, oh, the car's going 75 miles an hour. And then if I said, well, I don't think the car was going that fast, right? If I'm on the stand for some reason as a witness, I'm like, I don't think the car is going that fast. Didn't you say that you thought the car was going 75 miles an hour? Objection, hearsay, counter, present sense impression. It's what he said as he was observing it. Sustained or overruled. The witness may answer, yes, I said it. And then I have to explain the difference, you know. I have to explain why I said at the time it was happening, oh, it's 75, and now on the stand I'm saying, hey, I wasn't going that fast. So now I have to explain something, and anytime you're explaining, you're losing. It's always a good, yeah. Anytime you're explaining, you're losing. It's always it's a good rule in politics, it's a good rule in law. So that's present sense impression. So I don't really think it counts as present sense impression because in this example, Ethan Crumbley is describing his feelings. He's writing, you know, I feel sad, I feel depressed, I want to kill the people, etc. and so forth. And I'm like, I'm not really sure that counts as present sense impression because he's theoretically observing his own mind, but of course he can be deceiving himself in his thinking. I'm not really sure that it's the same thing. So yeah. The same journal my dad doesn't know is apparently hearsay. Although it's present sense impression his dad didn't know. I don't know. Do I have a bad neck? I tilt? No, my neck is fine. What kind of question is that? No, my neck, I tilt? I don't even know what that means. I tilt. No, my neck is fine, thank you. It might be an artifact of where the camera is, because if I'm looking straight at the screen, if I'm looking straight at my own screen, my eyes are here. If I look at the camera, my eyes are here. So it might be an artifact of where the camera is in relation to my screen, or if I happen to be looking down at my desk for some reason, if I'm having to look down, then I'll tilt, but no, my neck's fine, thank you for asking. I tilt? I don't even know what that means. I don't know what that means that I tilt. I don't even know what that means. Everyone tilts more on their dominant side? Oh, because my head is like slightly to the right? Yeah, okay. Well, maybe my head is slightly to the right. I don't know. It's just my posture. I don't know what to tell you, man. Yeah. So my head is slightly tilted to the right because it's my dominant side. Okay, noted. I could tilt the other way, I guess. Although that's a little bit more unnatural. And yeah, that doesn't feel natural. Yeah, this is my resting head position. I think I'll just stay there. That's fine. You think I left eye dominant? No, I'm not. I'm right eye dominant. I'm right eye dominant. I'm right-handed right eye dominant. Looks like my shoulder's below the left. You guys are making me self-conscious. Did I agree with the verdict in the Jennifer Crumbley case? With respect to what the jury decided, yes. Because the jury made the correct decision based on the information and law they were given. So it depends, what do you mean? It depends with what do you mean by do I agree with it? Do I think the jury made the correct decision? Yes. Do I think that the law is correct? No. Do I think the defense presented the best evidentiary picture they could? No. So yeah, it depends a little bit what you mean by the question. Any chiropractors? I don't really believe in chiropractors. It's not my shtick. I don't really believe in it personally. If you believe in it, then fine, but we're not going to debate the issue. I'm just simply going to state I don't believe in it, and we're leaving it at that. Thank you. Was justice served? Well, again, that's a little bit hard to ask. They say justice is people getting what they deserve. So did she deserve it? I suppose I can answer it by saying I disagree with the law. I disagree with the Court of Appeals. I disagree with the legal standards. So no, I guess not for my frame. But then again, I disagree with the law sometimes, and that's part of being a lawyer too. My personal belief is not necessarily what the law is. So, yeah. What makes an eye dominant? The same thing that makes you hand dominant, right? You're left hand dominant or right hand dominant, or you can be ambidextrous. So one of your eyes is dominant. If you want to know which eye is dominant, here's a really easy way to do it. Okay, hold up your hand like this. Okay, Hold up your hands like this. So you have a little triangle in the middle. See the little gap there in the middle? Okay. Hold it like this. And put your hands away from as far as you can away from you. Okay. And as best as you can, with both eyes, look into the center. Okay. Now, slowly bring your hand towards your face. And naturally, it's going to come towards one eye or the other. Because as your eyes are unable, as both your eyes are unable to look through the space at the same time, it's going to drift towards one eye. And that's how you know which eye is dominant. Which is typically, but not always, the same as your hand dominance. So that's how you know which eye is dominant. And now you know. Didn't the appeals court say it had to be foreseeable on that day? That's what I read in the Court of Appeals decision. If so, why is it never mentioned in the jury? Outstanding question. I don't know. I mean, that's what I would have said as the defense. This is what they're required to prove. I would have been objecting like crazy to the jury obstructions, but we didn't see that from this defense lawyer. So I don't know. Why was it presented to the jury? Because the defense didn't make the right arguments, I guess. You did the test wrong, it's not working? Well, give it another shot. And if it doesn't work for you, there's probably some other way to do it, but yeah. Do you know what district court this is? It's the court in Kasha County? I mean, I could look it up, but we break Oakland County. There you go. Oakland County. I was close. So yeah, it's Oakland County Court. So there you go. So yeah, you can find it in the Oakland County website. You want to go look up some dockets. I'm not sure what kind of break we're on right now. We're just on break, and we're just passing time. Yeah, Oakland County Circuit Court. Yeah, there you go. Yeah, and so if you're cross eye dominant, if your eye is not the same as your hand dominance, that's a bit of a problem for shooters, because then you kind of have to like, that's not ideal if you're a shooter. If you're cross eye dominant, it really helps if your eye dominance is the same as your hand dominance. If you're cross-eye dominant, that makes things very tricky as a shooter. So either you have to figure out a way to train either your eye or hand. So either you have to figure out a way to switch it, or you have to compromise. And yeah, it's not ideal. Yeah. You're right hand dominant, but left eye dominant. Yeah, see, so you're cross dominant. So that would make it more difficult for you to be a shooter, because your eye's in the wrong place to properly focus on the sights. And so yeah, it makes it more difficult for cross eye dominant shooters. Was the defendant offered a plea deal? I'm not aware of any plea deal. I don't know. That's beyond my knowledge. What else can I ask for you answer for you while we're on break? We can talk about other legal things that are in the news, if you like. The Trump decision relating to him being kicked off the ballot by the U.S. Supreme Court was pretty cool. I was enjoying watching some of the clips from the left-wing media not being very, very happy with the decision. Keith Olbermann had this really spicy tweet on the issue, basically calling for the the abolition of the Supreme Court. Like they failed at basic reading comprehension. I'm like, did they really? Okay. That's interesting, Keith. All right. Houston so far is good. Thank you for asking. Nate, the lawyer, and I went to work out yesterday morning, and we had a great workout. It was very exciting. Nate, the lawyer, is going on vacation, but we're planning on going to the gym together 3 times a week. And we're also going to film it, we think. And then we'll cut it up and, you know, we'll put videos of us working out together and stuff on. And maybe that can be either on our own channels, I suppose on our own channels to start with. And then maybe if it gets really popular on its own, maybe it gets spinned off somewhere. But that'd be cool, you know? Nate the Lawyer and Uncivil Law Gets Swole, Part 1. The traffic, I'm on the outskirts of Houston, so it's not really that bad for me. But it's definitely noticeable. Nate was from New York. He moved to Houston about 6 months ago. He gave up Manhattan for a more quiet life. Nate's about 15 minutes away from me, give or take. And that's a little bit further than that for me. 25 minutes. It's close enough. It'd be nice if we could find a gym that's somewhere in the middle, though. So I don't have to drive as far. But, you know, we'll make it work. Do I miss Austin? Not particularly. There's nothing really keeping me in Austin, to be honest. I didn't really have anything for me in Austin. There was nothing for me there. So there's nothing about Austin I particularly miss. I can't say that I dislike the city, but there's just nothing for me. Nothing keeping me there. And it is a little cheaper in Houston, I have to say, and I get a little bit more for it, which is nice. I've got something like 200 square feet more for $150 less a month. So that's nice. Plus, I've got a much better view than I used to have. Plus, it's much quieter than I used to have. So I'm a very happy camper. Plus, I got this new background with the blue lights, which is fun. And the things on the shelf, that's fun. This much more professional look, which I'm digging, rather than, you know, random background in my kitchen. So that's nice. I don't exist on X. Yeah, I know. For some reason, this particular thing doesn't seem to really like the Twitter account thing. Sometimes it's there and sometimes it's not. I contacted the developers. Hopefully it will come back. Hopefully it will come back. How you doing, Melissa? Good to have you here. We had a successful workout at the gym yesterday. So that was good. Love the background. I love it too. How long is the break? I don't know. We're just kicking on as long as they want to hold. I'm not sure how long the break is. We're just killing time. I could work on my social media pop-ups. I might as well try to do something productive. Devs didn't pay the app fee for X. Yeah, maybe. I don't know. Thoughts on Fonnie Willis? I think that, at least in my humble opinion, it seems to come down to what the correct legal standard is, whether it's actual conflict of interest or merely a perception of conflict. Based on what, I haven't done the super deepest dive, so I could very well be wrong, but based on the limited dive I have done, it seems like actual conflict is the correct standard, and it's not clear that there's an actual conflict. So I think Fonnie Willis is dirty. I think she benefited personally from her hiring her paramour. I think that she lies about, you know, having paid for everything. Everything's in cash, don't you know? Sure it is, right? But whether or not that amounts to an actual conflict of interest, I don't think it does. So the question seems to be, at least, is actual conflict the correct standard? Or is a mere perception of conflict the right standard? And if so, what does perception of conflict really mean in this context? Because, well, you could argue the prosecutor always is as a perception of conflict because, well, the prosecutor wants to prosecute people. They're not a neutral. So perception of conflict isn't the same thing it would be for a judge, right? The judge is biased. The judge is conflicted, among other things, if he's going to be biased for one side or the other. But that's not true of the prosecutor. They're supposed to be biased for one side. So what does a conflict of interest look? What does a perceived conflict of interest look like for a prosecutor is a reasonable question too. So my prediction for Fani Willis is 3-2 against. I think it is more likely she stays on the case than not. But I have to say this. I was incredibly impressed by the judge. The judge might be one of my more favorite judges in recent memory. He seemed incredibly open-minded, and he seemed exceptionally well-informed on the law. To the point where if he asked the parties a question, and they didn't know, and he's like, that's okay, here's the answer. So like, at some points, he was basically being forced to answer his own question because the parties didn't know, and he was like citing footnotes and stuff. The hearing was as neutral a hearing as I could imagine. It seemed incredibly fair, and the judge seems incredibly interested on getting the law right. So I have a lot of respect for this judge, and I really look forward to his decision either way, because I anticipate that either way the decision comes down, it will be a well-informed and legally sound decision, and so I look forward to reading it. Any thoughts on the State of the Union? I don't have any particular thoughts on the State of the Union. I think it's a bit of a... I don't really like the State of the Union as a concept. I prefer that we just go back to doing it on paper, unbreaded. But yeah, the pomp and circumstance of the State of the Union, not really my thing. If I were a member of Congress, I'd be like, I don't really want to go. Not because I have anything against the president, just because I can't be bothered. Like, I just don't want to do this. You know, I don't want to get up and sit down. It's like, I just can't be bothered. I'll watch it at home. I'll let you know my thoughts later, you know? No. That's regardless, you know, unless I guess I was particularly enraptured by the president, whoever it happened to be, because I just thought he was an outstanding speaker, and so I wanted to hear it in person. But short of that, you know. Yeah, the judge was looking to see if there are other interpretations other than what he found, of course. Of course. So the judge is asking the question to see if they have other ideas. And of course he is. And he's like, well, here's what I think the answer is, you idiots. But yeah, he's like, I've done all this research, and it's like, do you guys have anything else? Do you guys have any other ideas? And it's like, they didn't seem to understand the ideas he had, let alone, you know, new ideas. So the judge was definitely the smartest person in the room, which is always nice. Yeah, State of the Union is a meeting that could have been done in an email. Yeah. It used to be done in writing. For a long time, it was done in writing. Like, just bring it back in writing. Just bring it back in writing. Like, I can't be bothered. I don't believe there's going to be anything positive really said at the State of the Union. The only sort of over-under bet here is whether Joe Biden can actually get through the State of the Union without stumbling, forgetting himself, being confused as to where he is, forgetting whoever. I mean, he does have the benefit of a teleprompter, so all he has to do is read. But that's the only thing is the train wreck element of it. If Joe Biden has a real train wreck, which is a distinct possibility. So, yeah, that's the only reason to watch, is to see if there's a train wreck. But if there's a train wreck, that's okay. I'll catch it on the clips and the aftermath. Or saying God save the Queen? Yeah, something like that. Although, to be fair, I've done that. I keep forgetting that there's a king. You know? So, although he's the head of state, so it's a little bit more important for him to remember. So, fair enough. He'll call out the Republicans for refusing to do anything on the border. Yeah, I mean, certainly he will. I mean, yeah, certainly he will. He just is not going to say anything interesting that I haven't heard or that I care about. You know? He's not going to say anything I particularly care about. if he talks about Israel, Palestine in the State of the Union and basically renews calls for ceasefire, I'll be a little bit grumpy. But I definitely can foresee that happening. I'll probably talk about the Ukraine war, I can imagine. Court resumes in about 20 minutes. That's cool. We can just hang out together. Need to ban teleprompter? During Jennifer Crumbley's trial, the judge never would sustain or overrule. She would generally rephrase. Is that normal? Not particularly normal, no. But some judges are more active than others. And they just want to cut to the chase a little bit. So, fair enough. As long as they're being fair about it to both sides, I have no particular objection to that. As long as they're behaving fairly to both sides and being like, well, okay, let me see if I can rephrase this and save ourselves some time, then that's fine too. That's okay. Is Trump off the election ballot in all 50 states? No. Are there any good trial highlights we can watch for only those who are on Rust till now? I don't know about that. Thank you for covering this. My aunt taught for Brandon School District, which Oxford High School is part of. I'm not sure about the charges, but I'm glad the parents are being held accountable. Well, of course, I, as a legal commentator, care about the law. I mean, I appreciate the desire to see the parents held accountable in some sense. But my concern is whether or not they can be properly held to account under the law as it existed, especially in a criminal context, right? We shouldn't allow our general desire for the parents to see justice to overcome the law, especially when it comes to like criminal law, right? If there's not a law that fits, then there's not a law that fits. Maybe that's a good reason for passing a new law, but you just have to judge things, of course, by the law as it existed. You have to be faithful to the law. Do I think Alec Baldwin will be convicted? I think Alec Baldwin's defenses are a lot more interesting than Hannah Gutierrez Reed. I think his defenses are a lot more interesting. Alec Baldwin can make the very credible argument that he, as an actor, has been... Here's what I would imagine Alec Baldwin's defense is going to look like. Here's my best guess. All right, something resembling this. Hi, my name is Alec Baldwin. I've been an actor for 40 years. As an actor, my job is to put on a performance and to assume a persona that will be effective on the screen. In furtherance of this, I have devoted my life to learning how to do characters and to present emotions and all the rest of it. That is what I do. In the movie industry, there are a lot of other professionals who do a lot of other things, many of which I do not do as well, and some of which I can't really do at all. There are directors who help direct the movie and help the actors tell the actors what they want them to do. And there are producers who put together the movie to help finance it. There are stunt people who help do the stunts. There are safety people who help produce the safety, and so forth and so on. And throughout my career, I have relied on these people to do their jobs because I am not capable of doing their jobs. I'm not capable of doing their jobs. I'm not the grip. I'm not the key person. I'm not the sound engineer. I'm not any of these things, right? I'm just the actor. That's all I am, is the actor. And one of the groups of people I've learned particularly to trust over the last 40 years of my life have been the safety personnel who have been responsible for my safety in any number of domains. I trust them when they hand me the keys to a car, that the car is going to work properly. I trust them when they hand me the rigging, for my body rig that's going to prevent me from falling or whatever to work properly. I trust the body rigging they give the stunt people to work properly. I trust that so forth and so. I trust the set designers to build the sets so they won't collapse. I go onto the sets every day and walk up the stairs of a set every day, hoping that the stairs will stay put, and they do. And one of the groups of people I've trusted in particular is safety personnel as it relates to guns. Because that's why we get them in the first place, because we all know that guns can be dangerous, And one of the reasons we do this in the first place is to make sure that we have adequate safety measures so that we can rely on those people, just the same way we rely on the people who build the sets and so forth and so on. And in the same way I've trusted countless of safety personnel and countless of armors throughout my 40 years of career, I trusted Hannah Gutierrez-Reed, just as every actor does, which inherently makes it a reasonable thing to do, by the way, because every actor does it. So just the way same every actor does. I trust on them to do their job and trusted on Hannah Gutierrez-Reed to be safe with firearms. And so I trusted her implicitly. I don't test my safety equipment. I don't test the stairs every time I go walk up them. I don't test the whatever, I trusted her implicitly. And that was a reasonable thing for me to do, to trust her implicitly. And therefore I'm not guilty. That's what I imagine his argument's going to look like. Chi-Town Nave gives $10 to say, is it hard to hit the like, share, and subscribe? No, it's not. Let's get uncivil to 150,000. That'd be great. Here's a little something for the protein shakes for your workout. Law nerds rule.
989FH.
Thank you. Good morning. Mark Keese on behalf of people.
Mary McDonald, on behalf of the people.
Good morning, Maria Lehman on behalf of James Crumbley, who is standing to my left.
Thank you.
Just trying to beat
Now, the prosecution's argument's probably going to look something like, hey, Alec Baldwin, here's like the 13 other times on sets that you've been given safety briefings by those armorers on checking the weapon and everything. I've called like other armorers on other projects he's done. Yeah, I certainly gave Alec Baldwin that lesson. I certainly told him to be careful with firearms, never point at people, blah, blah, blah. Hey, isn't this the guidelines for the Screen Actors Guild that you're a member of? Doesn't it say right here in the Screen Actors Guild that you, the actor, are supposed to do it? Wasn't that put in place after The Crow? So that every actor would themselves also check it? Don't you have a responsibility as well? Did you do those things? No, you didn't? Did you point at a person even though you were told not to repeatedly over and over again? You did? Oh, okay. So there's that. So that's what I imagine the prosecution's case is going to look like. And then you have these competing narratives. So it's a lot more interesting of an argument.
Edward Rakowski, go.
Did you raise your right hand? You swear or affirm the testimony about the way you yourself?
Yes, ma'am.
You may be seated, and then would you state your name for the record as well as person.
Name is Edward.
What should you do after you hit the share button? What you should do after you hit the share button is to share this on social media. You should go to Twitter and retweet this thing.
Sure.
You should retweet it to everybody.
The U.S. Secret Service.
Make sure to help bring knowledge out.
The title is a network intrusion forensic
That'd be great.
analyst. I do computer forensics, cell phone forensics, network intrusion stuff as well.
And how long have you been working with the United States Secret Service?
2 months now.
And prior to that, where did you work?
I work with the Oakland County Sheriff's Office.
And what did you do there?
Before I was in the computer forensics unit.
Okay. So before, I take it you retired from the Sheriff's Office?
Yes, I did.
Okay. Before retiring, how long did you spend there?
My entire time there was 28 years. I was in the computer forensics unit for 10 years.
Now, if you could tell us, please, what a detective with the Oakland County Sheriff's Office Computer Crimes Unit would do on a day-to-day basis.
On a day-to-day basis, our job was electronic evidence, whether it's a cell phone, computer, DVRs from a business, whatever it may be. We were the ones that handled that. We're the ones that had the training how to get the data from that or get the video from it or interpret call detail records.
Okay. So Exhibit 43, it's been admitted it's your CV. I'm not going to go through the whole thing. But is it fair to say that you've had specific training for your role there?
Yes, sir.
Okay. Tell us about some of it.
The main training that we go to with the Sheriff's Office was there's an organization called IASIS to become a certified forensic computer examiner. That has a 6-month testing process after 2 weeks of training, after training about once a year. On top of that, for cell phones, there's other agencies. Celebrate has training they do for the tools that we use from them, and other agencies as far as PACCs.
When you say Celebrate, what's that?
Oh, I'm sorry. Celebrate's a company, and they develop software and have tools to extract data from phones and then interpret that data.
How often in your employment with the Sheriff's Office and the Secret Service would you say that you actually analyze cell phones?
Almost every day. That's what we do.
Okay. So you went through a lot of, just now a very quick rendition of detectives' work with the Computer Crimes Unit. I didn't catch most of that. Can you simplify a little bit of that for me?
I mean, so we get the data from the phones, and then we have to take that data and put it in a format that an officer in charge of a case, an OIC, is able to look at easily. Instead of sitting there scrolling through the phone, potentially changing data, we put it in a format, we take it off of there.
What do you mean by data?
Everything on the phone, anything. Text messages, call logs, pictures, videos, anything that's on the phone.
So the goal as a detective, when you take somebody's phone, I take it that's via search warrant?
Via search warrant consent, yes.
Okay, so if there's a judicial authority for you to look inside the phone, then what do you do with it?
Depending on whether the phone is locked or not, we use methods to obtain the passcodes and then extract the data or the call logs and the messages and all that stuff. And then that's, like I said before, we put it in a format that is easier to look at.
Okay. And what's the overarching goal of a detective in the computer crimes unit? What's the goal to obtain that information for?
What you want to obtain is all the evidence, if there is any, for prosecution. You want to make sure you get everything that is possibly on that phone to turn over to either the officer in charge of the case who will turn it over to the prosecutor's office.
Okay. So you're with the Secret Service now.
Yes.
In this field, this specific field, do you work with other agencies as well?
Yes, sir.
Tell us about that, please.
Same as with the sheriff's office. Any agency that reaches out that doesn't have the means to have the tools to get data off of phones, we just help them with it.
So we started to talk a little bit about your training in computer forensics. Have you been qualified as an expert in the past in this field?
Yes, I have.
How many times?
14 times.
In what areas?
Cell phone forensics, computer forensics, and then call detail record analysis.
Okay. What's called detail record analysis?
Call detail records are what you get from your carrier. If you have AT&T or T-Mobile, via search warrant, you send it off, search warrant off to that carrier to get information on the specific phone number, what towers they used, where the device might have been, stuff like that.
Okay. You mentioned cell sites.
And yeah, cell tower locations.
What's that mean?
The cell tower location is, it's an antenna for your phone, sort of like it is for your car. They're all over the place, wherever, probably within a mile of each other, half a mile of each other, depending on the population of the area. But it gives us the exact location where that cell tower is.
Okay. So in your over 10 years of experience working with the digital extraction of data from cell phones, would you say this field has changed?
Yes.
Okay. Is your training continuing?
Yes, sir, it does.
Why is that?
Well, just because the information changes, where an app might store information within the program itself, the little program, might change on every update. So we have to know where we can go to find it if the tool can't find it for us.
Okay, when you say the tool, what's that mean?
The Celebrate software, either the physical analyzer software or other methods to get the information off the phone.
So then would it be fair to say that as technology has changed and evolved over time, so is the training of computer crimes detectives?
Yes, sir.
And is that training continuing?
Always.
So for this time, I'm going to move to qualified witness as an expert in the field of cell phone forensics and historical cell site analysis.
Okay, he said computer forensics, cell phone forensics, car detail analysis. Are those the areas?
That's what he's been qualified in the past, called detail records, but in this particular case, he's going to be qualified as an expert in the field of cell phone forensics and historical cell site analysis, Judge.
Historical cell phone. Listening.
No objection, Your Honor.
You may consider this witness as an expert in your historical cell phone analysis and cell phone forensic analysis.
Thank you, Judge. Cell site analysis.
Cell site.
Thank you, Judge. Sir, you mentioned that the overall goal is to extract as much information as possible. Would that be right?
That's correct.
Okay. So in a digital investigation, would you confine yourself to just the cell phone?
No.
Okay, so what else? What other areas would you look for information?
Outside the cell phone, the call detail record isn't stored in the phone. We have to reach out to the cell carrier. A particular app, whether it's Facebook Messenger or Instagram or whatever, we can search warrant them to get information for somebody's account.
Okay. Now, if you could tell the jury a little bit, please, about what a cell phone does that might not be commonly known.
when you're not using it, when you're not interacting with it and swiping up and down and stuff like that, it could be updating your email, because you don't always tell the phone to update, it just does it by itself. Or it's talking to a cell tower to know exactly where you might be in case it needs to send you a message, or it knows whether you're not in range or not, so the carrier knows to hold on to that message. There's a lot going on in the background that people just, don't know the function's happening, but yet it's continually happening.
Is that while a phone's powered on?
Oh, yes.
Okay, so what happens if the phone's powered off?
Nothing. They can't do anything. Can't receive information. Can't send information.
Okay. Now, what about Android phones specifically? Have you had the opportunity to be trained in data extraction from Android phones?
Yes, sir.
Okay. Is that the same as Apple phones? iPhones?
Not entirely. How the operating system is written, it's a little different in the process of getting the data off of the phones.
What do you mean?
On Android phones, it's a little bit easier to get the data off of a phone than it is an Apple phone.
You said operating system. What does that mean?
The main function, when you look at the phone, with the main screen, that's the like Windows for your computer, right? Or iOS for your Mac or whatever. The operating system is the base of that phone, whether it's Android or an Apple that uses iOS, an Apple phone. That's the main thing that makes the phone function.
Okay, and I think you said that Android operates differently than Apple?
Yes, it does.
Okay, can you explain that to me again, please?
It operates a little different on how it stores data, how it retains that data, whether it's a file-based encryption, whether it's even encrypted at all, depending on the phone that you have, the manufacturer of that phone, and where it stores that data.
Now, are you able to obtain someone's locations based upon the device?
You can, yes.
Tell me how that works.
The phone's always looking where you are. Obviously, it's talking with towers. The tower tells the phone where it's at. For advertising purposes, let's say Google, for example, they put those little cookies on your phone so it knows where you're at all the time, right? And it knows that you like going to Burger King. So every time your phone knows that it's near Burger King because the map app is being used, it's going to tell you, oh, there's Burger King nearby, or it'll pop up in your Facebook message feed or whatever. So that's, yeah.
All right, cookies, what's that?
Those are little trackers, I guess, to make it simple. It's a little tracker that's embedded in however the phone interacts with either the internet or an application. It's a little nugget that just sits on your phone, waiting to be activated to tell either Google where you're at, Apple where you're at, and to give the user a better experience with their phone.
So if I'm on my phone and looking at a website, for example, and I get that little bar at the bottom that says this website uses cookies, accept or yes or no.
Yep.
So if I either hit yes or I close out of that box, then it's tracking my phone.
If you hit yes, correct.
Okay. What if I hit no?
Then the cookies, they're not installed because you're not giving permission for them to be, loaded up to your phone, not installed, loaded to your phone.
So in order for me to look at the website, for example, though, I have to hit yes.
Not necessarily, no.
Okay.
No.
So this is something that, as an investigator in this field, you're able to use to help understand the location of the device?
Correct, yes.
Okay, and tell me how that works.
Well, like I said, one of the main things that we use is what's called location services. Location services is what tracks where your phone is within either an Apple or an Android phone. Google stores that data, again, because it sells that data to Burger King or wherever that you might want to, whatever you're interested in. And it keeps track of where you have been, where you like to go to use that information in the future.
Okay. So I want to talk about specific to this case. I want to talk about some of the evidence that you reviewed in this case. First of all, were cell phones seized in the course of this investigation?
Yes, there was.
Okay. And you were the individual, you and members of your team had the opportunity to review those cell phones?
That's correct.
Okay. What about information from social media outlets?
Yes, we did.
Okay. Now, regarding cell phones, I'm going to summarize this, and I want you to tell me if this is accurate, okay? So source of electronic information from the shooter, the Android phone, T-Mobile phone, last four digits, 1551.
Correct. Yeah.
That's right?
Yes, sir.
Okay. A Facebook account? Correct. Instagram account?
That's correct.
Okay. Now, regarding Jennifer Crumbley, there were 3 cell phone seized, is that right?
Correct.
Okay. So we have 2 from T-Mobile with the same identical phone number. Is that right? Okay. a TCL A509DL, we refer to as a burner phone. What does that mean?
Burner phone is what we refer to. It's a phone that you can go to Walmart in the electronics section where they sell their TVs or any CVS or Rite Aid, and just buy it in a packaging and activate it. The SIM card's in there, and there's really no account that's needed to get it up and going. You just activate the phone by putting money towards the account within it.
Okay. A Facebook account, jehn.crumbley.7, and we have includes the messenger functions. What do you mean by that?
So Facebook Messenger and Facebook, it's two separate platforms. But you can search more on Facebook for Messenger information, or you just search more for Messenger information.
Okay. And then we have a certain email account from Gmail and Yahoo.
Correct.
All right. And then the Instagram account, JEHNC78.
Correct.
Okay. So regarding James Crumbley, again, 3 phones were seized, 2 of which were T-Mobile phones with the same phone number, and the third being the TCL A509DL burner phone.
Correct.
Okay. 1 Instagram account, James R. Crumbley. 1 Facebook account, which included the messenger function, James R. Crumbley, and Yahoo, Gmail, Charter Communications email accounts.
Correct.
Okay. And then DoorDash search warrant for James Crumbley. So was the search warrant issued to DoorDash?
Yes, it was.
Okay. And information received?
Yes, it was.
Okay. So we spoke about that very briefly early. A search warrant is when a judge or magistrate authorizes a document to a social media provider or a company, for example, and information is returned.
Correct.
Okay. And so what happens when you get that return?
Sometimes it's in an easy format. It's just a simple Excel spreadsheet. Other times it's multiple Excel spreadsheets that you have to compare different parts of that 2 spreadsheets to come up with the information.
Okay. Now, your role normally would be to talk about cell phones, computers, cell towers, things like that.
Correct.
Okay. So, with your permission, I'd like to talk to you about November the 30th, 2021. Do you remember that day? You were working for the sheriff's office?
Yes, I was.
And you were a computer scientist?
Yes, I was.
Were you working that day?
Yes.
12:50, 12:51 in the afternoon on November the 30th. Do you remember where you were?
It's probably driving pretty fast.
Okay. And tell me why.
We got news from our captain that there was a shooting at the Oxford High School. Prior to that, our sergeant who was off that day reached out, texted one of the guys in the office and said there was a shooting at the high school, and nobody believed it. Like, we believed it, but we're like, that's just somebody nearby at a house, fired off a rifle or something, and the police are going to go do their job. And then a couple minutes go by, and the captain comes in and he said there's been a shooting at the high school, and he said all hands on deck.
Okay. What did you take that to mean?
There was a shooting. It was
All hands on deck. You're not normally somebody who responds to active shooter situations, right?
no, it's all the nerves. When for the captain to come to the computer crimes office, it was all due respect to the guys in there and the gals in there. That's not their job to deal with that. The fact that he came in there it was a really big deal.
Okay. And you mentioned you were driving pretty fast. Tell me about that.
I remember getting out to my car. At the time, I had a white minivan that had lights and siren in it. No one ever took it seriously when you turned the lights and siren on. But I remember pulling out of the parking lot, and I looked to my left, and there's, it didn't seem real. It didn't seem like this. Like, I'm thinking in my head, like, this is just blown out of proportion. Because I didn't have my radio on in the car. I couldn't hear the radio traffic at the time. And I looked to my left, and there's 2 patrol cars, not even from our agency, not even from the sheriff's office, come around the far corner on this complex by the medical examiner's office and animal control. And they turned that corner on 2 wheels on each side, and the back coming around that corner, their lights were shining, they were going fast. And I'm like, holy cow, this is real. So then I turned my lights on because I just thought we'd get there and do what computer crunch does, you know? We would do our thing. And I turned my lights on, the siren, and I started going north towards Walton. Telegraph runs up to Walton and it cuts over the M20, US 24. Telegraph cuts up to Walton and it goes over to M24. And I had no idea where the heck I was going. I've been to Oxford for a half a second driving through. And I thought, well, I remember thinking when I get there, I'll just follow the crowd because it's going to be big. And going north on 24, and I see one of our SWAT vehicles going across the bridge from 75 down to 24, and the light was red for me, and I thought, well, I'm going to have to slow down, like, there's cars coming down the ramp. And I remember getting closer and closer thinking, how come nobody's going? Like, my light's red, this cross traffic should be going. Like, because as a police officer, obviously, when you run a red light, it's extremely dangerous. You don't do it haphazardly. And I'm approaching this light thinking, I'm going to have to slow down. And as I get to the light, I look over and there's a patrol car just sitting. I don't know what agency they work for. And so I go through that intersection and I see them join up behind me, and then I see two other patrol cars from another agency coming up behind me. I remember, I don't know if it was Brown Road or what, the next major crossroad up the hill there. I remember that light was red and there were cars stopped in both lanes, and I thought to myself, I'm gonna have to go onto the shoulder. And so I'm looking at the shoulder thinking, I mean, it's part dirt. It's a small shoulder of asphalt and dirt, and my small tires on that minivan, it's not gonna handle well, but we're not going to stop going, right? So I remember feeling the steering wheel shaking from the gravel, and I get around and keep driving north. Crowd still following me. I look up in the mirror every once in a while, and there had been, I couldn't count them. They were so far deep behind me, and the ambulances and the SWAT vehicle, and we get up into town, up into Oxford, I think we were. And as I'm approaching the light, it just changes red. So obviously cross traffic doesn't know what's going on there. You might just have somebody that just goes straight, and again, it's dangerous. It really is. And so with the lead car, I've always been told the lead car in a situation like that, you always hold that intersection for everybody else behind you because they're coming. And so as I edged into the intersection, I stopped dead in the intersection with the lights and siren going. And I counted at least 16 vehicles were still screaming past me. And we start getting into town, and northbound traffic's blocked. It's dead stopped. I remember going against oncoming traffic, and you see cars coming at you, you know, and you're the whole way there, all I could hear on the radio was staging area on Ray Road, Meyer. What I kept on hearing, there was so much radio traffic. I heard bits and pieces of other things, but that like really stuck in my head. And so we're just driving north, and finally I just see a Meyer, and I'm like, okay, well, we gotta be far enough north. This is where I gotta go. And so I pull up onto Ray Road, and I meet up with other deputies in the area.
If you could describe to us what you saw when you arrived at that Meyer.
That was tough. That was really tough. I got a daughter who, she's 17, 18 years old, and, 17-year-olds, they wear those tight leggings and all that stuff and small shirts or whatever. I remember standing there on Ray Road, and I see these kids. One kid didn't even have a shoe on. He only had one shoe on. Walking through the snowbank, going down to the Meyer. And I see these girls dressed like my daughter. And it was cold that day. I had two coats on, and I was shaking. I was shivering. It was so cold. I remember offering one of our lieutenants at the time. He didn't have a coat. And I offered one of my coats because I was so cold, and he didn't take it. But you just saw these kids just coming down from where the school was. Like, it's hard to describe. They look like they looked like zombies. Like they had no facial expression, nothing.
So they were their parents at the Meyer too?
I'm at the garden center. The crowd was heading that way, and it was chaos. It really was. I really didn't know what to do once I got there. I didn't know where the school was, even though it was just up the street. So everybody was walking to the garden center, so I started going that way. And at first, we were told to get people to sign their name into notebooks. We were just grabbing them off the shelves in the Meyer and boxes of pens and stuff, and just write their names in the notebooks for whatever. I don't know why they needed that. So I'm trying to walk around and get this information from people. And then they started yelling. Someone started yelling, get everybody inside, get everybody inside. So I go back outside to try to usher people in. And I remember just seeing kids just standing there, and you put your arm on them. You don't want, they just send this, whatever happened up there. And I don't want to force them. I'm not going to grab them. I'm not going to make them do anything they don't want to do. So I sort of, if they didn't move, I just left them. They were okay. They weren't in harm's way. And I remember seeing parents just standing there, and these school buses started arriving. And I remember thinking in my head, God, that is just crazy. Why in the heck are there school buses? I didn't know anything about the plan when something like this happened at the school. And so I just see the parents, you see them just almost praying and grabbing that their kid came off the bus.
After you helped with the names and the notebooks, did you go to school?
Yes, I did.
And were you directed to go to school, or did you just know that's where you were needed?
No, one of the other detectives, Jeff Enger, he responded to the school, and he called me on my phone and said they were trying to get the video from the surveillance cameras in the school. And at the time, I was a little more versed in that side of the job. And so he just wanted a little help with it.
Okay. So tell me about, you arrived at the school. Where did you initially go?
I went to what would be the north side of the school. There's a big circle drive there, and it's the side that the main office is on of the school. Again, there were patrol cars everywhere. Everybody everywhere. I remember driving up over the sidewalk, thinking, I remember the stuff I remembered, the sidewalk being so high, I thought it was going to rip the muffler off my car. I don't know why I thought about that. And I go up over the sidewalk, and I just stopped my car because that's what it seemed like everybody was doing. And I walk in the door, one of our sergeants is standing there, provides security just for that door so people aren't coming in, they shouldn't be coming in or whatever. And I asked them where the security office was, because that's where Detective Enger told me he was. And pointed me to the office, and people eventually pointed me back to the security office.
Okay. And who did you encounter when you went there?
As I walked in, I remember seeing the security officer, Jim Rourke, was in there. Deputy Jason Lewert was there. I didn't know him at the time. ATF agent Brett Brandon was in the room.
Right here behind you.
Yep. And Lieutenant Marsban was in the room.
And you said at that point you were called over to help with the security footage.
That's correct.
Okay, so tell me what your role was.
Obviously, the bosses are going to want to know what happened, where it started, all that information, and I wasn't given any direction. We weren't given direction, but we just had to figure out when it started, where it started, how it started, as much as we can, because they're going to want to know that information. And so we just started reviewing video footage.
At that point in time, was the high school still being cleared?
Yes, it was.
And when I say being cleared, we haven't had another officer testify yet. What does that mean?
To clear something, you're going to look for more bad guys. You want to look for maybe bombs that might have been placed, someone hiding in a room because they know the police are there, so they're checking every room, every closet, everything in a high school, going door by door, checking it all.
So tell me how it is that you went about your job, that you were called there to do that thing.
Jim Rourke, like I said, he was a head of security. And they had a system where you didn't actually interact with the DVR system itself. You interacted through a portal, a webpage, to access the server where the video was stored at. And thank goodness he was very well versed in that. So I immediately, I told him, I said, well, you got to help me figure this out because I don't know what's going on here. So Jim and I sat there, went to the hallway that started, and tried to determine at what time the shooter went in there.
So how many cameras approximately did Oxford High School have equipped for surveillance footage?
Well, they released 100 cameras.
Okay. And it was your responsibility to review that footage?
Yes, it was.
Judge, this might be time for a natural break.
Oh, all right. Well, the jury's lunch is here. So that would probably work. I'm not sure if I call you Sergeant, Detective, Lieutenant, Mr. Amy, none of those? Okay, all right. You should not discuss your testimony because you're starting to get us. Please don't discuss your testimony with anyone. All right, so you can step down. If I leave until 1:15, is that? Yeah? Okay, those who ordered lunches, your lunches are here, all right? Do not discuss the case with anyone, don't text anyone, right? Okay.
All right.
All right, you can take it.
The court prepared for ruling on exhibits 133, 153. They would be through this officer's.
Okay, all right. I'm going to take care of it. Right? I'm trying to hit, I don't want to release the jury, so please.
Yes, yes.
Did they say what time they were coming back? If they did, I missed it. So I'm asking you guys, did they say what time they're coming back? So that anyways deals with the morning session. So kind of the same thing we saw with respect to Jennifer Crumbley. No major surprises so far. Not that you'd really expect there to be. You didn't hear them say a time? 1:15? They said 1:15? All right, so that's an hour from now? Cool. All right. 1:15? Cool. All right, so we'll take a break till then. So I'm just going to give some concluding thoughts, and then we will end the stream so that I can get some lunch and you guys can get some lunch too. But we will come back for this afternoon session because so far, so good. Cool. All right. So yeah, kind of what we expected to see so far. The state's opening was good, 8.5 out of 10. It was perhaps a little paint by numbers. It could have used a little bit different of emotional tonality. It was a little monotone. Could have used a little bit more vocal variety, but it did have some specifics in there. It walked through the event. It didn't overstay its welcome, which is always appreciated by me. It didn't go on very long. It was, half hour, 40 minutes or something, perfectly serviceable. Could have used a little bit more using the space, moving around a little bit more. But 8.5 out of 10, perfectly serviceable. Nothing to complain about. Fine opening. The defense's opening certainly was much better than their counterpart in Jennifer Crumbley's opening. I'd say 8 out of 10. It was fine, but made me a little bit worried because it lacked specificity with respect to any evidence that we might expect to see that would help the defense. And we didn't hear any sort of indication that they have an expert, for example, who will be able to testify about these events being unpredictable, even by experts. And that would be, of course, very valuable information. So they certainly did a fine opening, but it lacked any specificity. And of course, as I've mentioned before, openings are not, you don't tell the entire story, but you do tease the story. You know, you want to give enough information, like you will hear from this witness, we'll testify about that. And you don't necessarily have to do it in those words. You can do it a little bit more softly, which is perfectly fine too. But here, there was really no major indication from the defense about what the defense is going to be. You know, they're going to tell you to look at this, we're going to tell you to look at this. They're going to tell you this, we're going to tell you this. So it's just kind of echoing without any clear direction or contrast. So a fine opening, but unfortunately suggestive that perhaps the defense doesn't have much to work with. And so I'm concerned that their defense may look a lot like Jennifer's defense and may therefore wind up in the same result. But we, of course, will see when we get to the defense's case. I wouldn't expect there to be major differences in the prosecution's case. There may be different questions asked. There may be different cross-exams. There's already been evidentiary rulings in favor of the defense with respect to particular text messages that were excluded and things like that. So some wins for the defense today, although it appears the journal's coming in. Hopefully the defense will make a bigger deal about the journal, and that coming in would be really nice. And that's sort of where we're sitting on all those things. So that's kind of a summary of the case thus far. So are there any questions I can answer real quick before we go to lunch? And I appreciate the 578 of you who are currently with us. Just a friendly reminder, if you haven't hit subscribe, do that. And if you're a member of Twitch, you can subscribe, which is the paid option on Twitch. But if you have Amazon Prime, it costs you nothing. So I get money, but it costs you nothing. Jeff Bezos pays me, you don't pay me. So if you do have a Twitch account and Amazon Prime, we would appreciate, or I would appreciate, more the point you going over and subscribing on Twitch, twitch.tv/uncivillaw. All right. And then, of course, you just sync up your thing. Why is the defendant wearing earphones? Presumably because he's hard of hearing. And that's the most logical thing to think. I mean, I don't know, but that would be the most natural conclusion. He's problems hearing, and so he has headphones on to allow him to hear better. So that would be the most logical conclusion. Brandon says, I saw you on Legal Bites yesterday. I became a subscriber today. Happy to be there. Thank you very much. It was nice to see Alita again. It's been a while since I've collabed with Alita. So it was nice to drop in with her. Say hi. Yeah. He's worn the earphones every other appearance in court. Yeah, yeah. Yeah, so I mean, I don't know for sure, but presumably because he has difficulty hearing. So, fair enough. All right, well, seeing as there's no other questions, I will not be dilatory in giving you your well-earned break for lunch. So we will be back in about 45 minutes with new content. So that'll be fun. Until then, my friends, I've been Uncivil Law. Hope you have a great one. Until later, my friends, goodbye.